All right, Miss Anna. Good morning.
Morning.
Good morning, everybody.
Good morning.
Hey, just a reminder that we are being live streamed on YouTube as we speak. Is anyone going to have anything procedural that we need to deal with before we resume? Good morning, Mr. Lee.
Good morning, Commander Bond.
I don't have, I'm going for warmth today. No blazer. I actually have a sweater on. Might have to break up some of the furniture. Don't tell Commissioner O'Connell. Little chilly here in the room. Okay, Mr. Walker.
Do you want heat or do you want internet?
You know, as my mom used to say, it's not the decisions, it's the deciding. I want internet. I have a coat, so we're all good on that, Commissioner. Um, and and how exciting! I actually have Dropbox, so I guess I need to figure out. I think Miss Miller, you indicated yesterday that you couldn't get access to it.
No,
Um,
I thought I did upload or re-upload LES's exhibit and exhibit list, and hopefully it went through, but right after I did it, I checked the Dropbox and it hadn't appeared yet, so I'll check it again, and if it's still not in there, I'll do it again.
okay. Because I am seeing it. LES exhibit
Okay.
1.
Okay, excellent. Thank you.
Uh-huh. And I also see some others that were uploaded yesterday and one today. Okay, great. All right. We've got about 4 minutes. I don't have anything else procedural. Hearing Examiner Schaefer, do you have anything procedural that we need to talk about?
No, I do not. I think everything is operating very well so far.
Great. Excellent. Great. Well, I'm just gonna go put the teacup in the microwave, and I shall return, as they say.
When you're ready, Judge.
All right, sir. Very well. Good morning. We are returning to day 2 of our hearing in case number 25-00066. UT in the matter of SPS's, CCNs, and more. When we ended yesterday, we were conducting the examination of SPS witness Miss Lee's. We're going to continue with that. And Ms. Amer, I believe that you reserved 90 minutes for cross-examination. Please go ahead.
Thank you. Good morning, Zoe. It's good to see you.
Morning, Miss Aidner.
Yeah, this has been a marathon, and I understand that your testimony is an overview, and it references many other SPS witnesses' testimony. When I I just want to say at the outset, when I ask you a question, I understand that there are other people that may know more, but I'm really just asking what your understanding of a particular issue is. Because you did submit direct testimony and rebuttal testimony, and so it would be good to hear from your perspective. That being said, I would like to start off on a different note than other people have asked. It's about the economic development benefits that SPS and states will result from this project. And I want to backtrack a little bit to the standards that the commission has to address when approving a CCN. And I believe that's on page 57 of your rebuttal. And which I just lost on my screen. But basically it's in 6291 and it's the net public benefit test, and the cases you reference, case number 23-00252, and that essentially that the benefits to the public interest have to outweigh the detriments. So your application in general, and this is the question, do you agree that the benefits that you allege will result from this project are avoiding deficiency payments? There's several, but I'm going to go one at a time so that I don't ask a compound question.
So I'm sorry, Miss Amar, can you repeat your question?
So one of the benefits of this application is avoiding deficiency payments. Is that correct?
I agree that one of the benefits of the portfolio brought forth in this application is meeting the planning reserve margin requirements and meeting the system's reliability needs.
And in addition, another benefit is economic development to the state of New Mexico.
Yes, Ms. Amar, it is the company's position that this portfolio does bring economic development benefits to the state of New Mexico.
And another benefit would be meeting load requests.
Yes, Ms. Amar, another benefit of the portfolio brought forward in this application is that it enables the company to meet the demand on its system today in a reliable and cost-effective manner.
And another benefit would be to decrease the cost of the requested projects as by getting acquiring tax credits that could be passed on to customers.
Certainly a benefit associated with the portfolio is that there are production tax credit opportunities associated with some of the projects.
So all of those benefits are at question here. And at this point, I'd like to ask you about the economic development benefits. You indicate in your rebuttal and direct that while EDD did issue a certification, the extent of the certification was unclear. Is that correct?
That's correct. I did testify. I can't remember if it was my rebuttal or direct, Ms. Amar. So if you can point me to the page you're looking at, that would be helpful. But I did testify that the certification was unclear.
Right. I believe it was I know it was partly in your direct on page 24, your rebuttal on page 62 and 64. And okay, and you also state that this is not being, this application is not being reviewed under the Economic Development Statute of the Public Utility Act. Is that correct?
I believe my testimony was that we did not bring this application forward under Senate Bill 170, codified by 621626E.
I'm sorry, 6216.
62-16-26E.
Thank you.
So the commission should review this project as if that law were not in effect, and whether or not it has economic development benefits, like any CCN case brought before the commission prior to that statute.
Yes, my testimony is while we sought that certification, the certification we received is unclear. Therefore, we're not bringing this application forward under 62-16-26E.
And then in addition, you mentioned that Miss Leyva Tercero's testimony was, and unfortunately, I'm having a lot of trouble with my computer bringing up my rebuttal. So I would love to read it to you, but something to the effect that she stated that you cannot rely completely on the projections for economic development.
My testimony is that staff cautioned the commission on relying on benefits as stated by SPS. But that also staff conceded that there would be economic benefits associated with the self-build projects.
But isn't it correct? I believe it's a footnote. She stated some and caution. Those were both of her words.
If you could point me to where in Miss Leyva Tercero's testimony
It's on
that
page,
testimony is, I'll let Miss Leyva Tercero's testimony speak for itself.
okay, it's on page 62 and 64.
I don't have her testimony in front of me, Miss Emer. It's
Okay.
going to take me a minute.
Yeah, my Dropbox is not opening up.
What page would you like me to go to? Sorry, I'm
It
in Miss
starts-
Leyva Tercero's testimony.
It starts, no, your rebuttal, page 62 to 64. And
Oh,
you cite
yes.
to her, you cite to her testimony.
That's correct. I'm sorry, Miss Emer. I thought you wanted me to pull up Miss Leyva Tercero's testimony.
And I'm gonna have to pull this up a different way because my Dropbox is not working. You see your rebuttal. Okay, if you go to page 62, that's where you start to talk about economic development benefits. And she says it's page 48 of her testimony. I'm starting on page 63, line 5. Staff, quote, cautions the commission about relying on these benefits as stated by SPS, yet also concedes that there will be economic benefits associated with the self-build projects if constructed and approved. But then if you go down to line 11, you say, it is difficult to reconcile staff witness Leyva Tessero's cautionary note about the economic benefits alongside the concession that benefits will result. And then if you go to page 64, footnote number 84, it says, quoting Ms. Leyva Tessero's testimony at page 48, staff does not dispute that there will be some degree of economic benefits associated with the proposed projects if approved and constructed, as there are with any construction of new resources. So I don't understand how, why is that difficult to reconcile in your mind?
It's difficult to reconcile because while staff recognizes that there will be economic benefits associated with the proposed projects, it cautions the commission from relying on the evidence SPS has presented in this case on those economic benefits, but has not provided any evidence in this case that disputes the analysis that Mr. Teisling or demonstrates that the analysis Mr. Teisling does was inadequate or inaccurate.
Well, but isn't it true that staff is saying some degree, and that's their reason? It's reasonable to interpret that statement as, but not to the degree that SPS claims.
I'll let staff's testimony speak for itself, Ms. Amer. My testimony is that staff does not put forward any evidence that disputes Mr. Teisling's analysis. It just cautions against relying on it.
And I will speak to Mr. Teisling about his review, but isn't it true that staff doesn't have a witness that's an expert on economic development?
Kat, it is my understanding that staff has not presented such a witness in this case.
Right. And that it is true that staff cautions the commission about relying on the economic benefits stated by SPS.
As I summarize in my testimony, that is staff's testimony, and I'll let Ms. Leyva Tesero speak for herself regarding her testimony and what it means.
And how many of the resources in SPS's final preferred portfolio are located in New Mexico?
I believe it's 3, subject to check. In the final preferred portfolio, Ms. Amer, or in the portfolio presented in this case?
In this case, because in this case, we are just deciding the CCN application for the 7 projects here.
You can't testify, Miss Amer.
Okay. In this case, then.
I believe that there sorry, I'm just checking my the Sagamore Bess project is located in New Mexico. The extension of Maddox is located in New Mexico. And I think those are the projects contemplated in this application.
So would it be fair to say that it's a small percentage of the projects requested in this application?
In this application, 2 of the projects requested, 1 extension, 1 battery energy storage project, are located in New Mexico.
But the 2 large gas plants, Gaines and Polk, are located in Texas.
That's correct, Ms. Amer. The Gaines County CTG is located right across the state lines, and Mr. Teisling discusses that that still does bring economic benefits to the state of New Mexico despite being located in Texas. And he testifies that the portfolio as a whole enables economic development in New Mexico as well.
You mean the final preferred portfolio? Not,
Miss,
is that what you are referring to?
I believe Mr. Teisling provides analysis in his testimony regarding how available capacity and reliability improves economic development. And I'll let Mr. Teisling discuss that analysis.
But do you agree that the extent and the degree of economic development that will occur in New Mexico is an important factor that the commission should consider?
Certainly, it's an important factor that the commission should consider, and it is my testimony that this portfolio enables that development in the state of New Mexico.
Do you agree that that with any estimate of economic impacts, there's a degree of uncertainty?
You'll have to ask Mr. Teisling about what degree of uncertainty, if it's present, is associated with his analysis on economic impacts.
But do you agree that any projection of anything has a degree of uncertainty?
I don't understand the question, Ms. Amer.
Do you agree that projections of any future occurrence has a degree of uncertainty?
Certainly, hypothesizing about future occurrences, future changes are unknown. And that is present, I suppose, in any argument that you bring forward on what the future could hold. I think SPS is planning a portfolio for the known conditions that it has on its system today with the available resources to it today to meet the system needs that we are aware of today.
Yeah, I understand that. And you're basing those requests in the application upon certain projections, is that correct?
You'll have to talk regarding projections of load growth. You'll have to talk to Mr. Goodenough in terms of what the modeling shows on projections of reliability requirements and meeting those requirements. Mr. Gable can talk about that. I guess my point is that SPS as a company is planning a portfolio with the information it knows today to the best of its ability, and we can hypothesize about future changes in law, future changes in policy, any future changes, but the fact of the matter is those are not known today, and SPS must do the best job that it can do in order to plan today for the system.
Okay, thank you. Now I'm going to go on to another matter, which is you referenced in response to several questioners, page 48 of your rebuttal, about certain options. Can we go to page 48 of your rebuttal?
Yes, ma'am. I'm there.
Okay. Now, just as a general matter, when a utility files an application, they're requesting a particular decision from the commission. Is that correct?
Yes,
And in this application, SPS requested the commission grant an exception to the Renewable Energy Act 2045 zero carbon requirement. Is that correct?
yes, SBS requests that to the extent it deems it's necessary that the commission grant exceptions in order to maintain system reliability and safety and to prevent undue impact to customer bills.
So the burden of proof that SPS has is to prove that the exception is authorized by law. And if so, second, that this project qualifies for such an exception. Is that correct?
SPS has the burden of proof to show that the request qualifies. That's correct.
Does SPS have the burden to prove that such an exception exists in law?
As with any applicant, the applicant has a burden of proof to demonstrate that it deserves approval of its requests in front of the commission.
So then the options are laid out on page 48, and I'm not going to go through all of them, but there's many. There's 1, 2, 3, and then under 3, there's 3 bullet points. In essence, that appears, at least it could appear to be 3 different applications.
Objection.
Mr. Larson?
Object to the form of the question. Council's testifying at this point. I didn't hear a question.
Ms. Amer?
Rephrase it. Is SPS asking for approval of all of the 3 options?
No, Ms. Amer, my testimony is that the commission has a few options in terms of the Gaines County and Tolk CTGs in this case. One option, Ms. Amer, is that they could grant the CCN. Another option is that they could grant the CCN and approve the Renewable Energy Act exceptions that SPS has requested in this case. The third option is that the commission can grant the exception request that SPS has put forward in this state and require SPS ahead of January 1st, 2044 to come in with alternative proposals on the Gaines and Tolk CTGs in order to make them compliant with the Renewable Energy Act or to continue the exception that it grants in this case. My testimony then lists possible options that could be available in that check-in, but those are not separate applications in this case.
So is SPS standing by its original application that it would like Gaines and Tolk approved with the exceptions requested?
The original request in the case, we still stand by, and that request was to the extent the commission deems it's necessary to grant the company exceptions in order to maintain system reliability and to prevent undue customer bills, that it should grant SPS that exception.
In your testimony, I think it's on page 49, or let me get it. You state that it's on page 50. Does SPS have a preference among these options?
I see
Uh,
that testimony.
Right. Answer on line 2, no. But clearly, isn't it true that some of the options are better than others in SPS's standpoint?
As my testimony states on page 50, ultimately our preference is for a pathway for Gaines and Tolk CTG resources to be able to move forward and to provide that service to our New Mexico customers and to our Texas customers as well. We want those resources in order to keep the system reliable and to allow for customers to benefit from the economies of scale while driving economic development in both states. That's what my testimony says. And the 3 options are all acceptable to SPS.
But isn't it true that some of the options would create more uncertainty for SPS?
SPS, as I've testified, the uncertainty is created if there is a finding in this case, Ms. Amer, that SPS cannot recover the cost of these resources past December 31st, 2044. And that is the result that's unacceptable to SPS and would result in us having to re-examine whether these resources should be built for New Mexico customers.
And you mean when you say recover in 2044 or 2045, you mean recover from New Mexico customers?
Correct, Ms. Amer. I'm talking about recovering the costs of the resources from New Mexico customers.
Okay.
And if there is a holding in this case that SPS cannot recover those costs from New Mexico customers past December 31st, 2044, that would cause SPS to re-examine whether it can build these resources for New Mexico customers.
But could the commission determine that after beginning in 2045 that SPS recover from Texas and not New Mexico?
I do not believe the New Mexico Commission has jurisdiction over what Texas does or does not do in this case or in the future.
Oh, I agree with that, but I'm saying, could they state that those 2 plants cannot serve New Mexico and not get cost recovery from New Mexico customers, but they could still serve Texas customers?
I'm sorry, Ms. Amer, there was a lot of components in that question. Can you restate it?
Could the commission decide that Gaines and Tolk cannot serve New Mexico after 2045 unless Gaines and Tolk become zero carbon by that point?
I suppose that the commission could make such a finding. I think my 3rd option provides them a pathway to assess alternatives to Gaines and Tolk. But if we have an explicit finding that here in this case, that Gaines and Tolk cannot be used to serve New Mexico customers, nor can the company recover those costs for those plants from New Mexico customers after December 31st, 2044, the company would have to reevaluate whether it builds those resources for New Mexico customers.
But could the commission decide that it could approve the Gaines and Tolk gas plants and grant the CCN and simply say that if they do not comply with the REA by 2045, then at that time, the commission will decide how to handle it?
Again, I think option 3 provide in my testimony provides commission kind of a pathway to reevaluating whether these units comply with the New Mexico Renewable Energy Act, or whether at that time, ahead of the 2045 deadline, SPS is still required to have an exception because it's in the public interest.
But on page 48, line 10, you say you're talking about option 3. A third option is to grant a 2045 REA ETA exception with a future check-in before January 1st, 2044 to examine alternative proposals to make the gains and Tolk CTGs REA/ETA compliant, or continue the exception past 2045. That option would be to grant the exception with check-ins. But isn't there a fourth option that they could not grant the exception, but have future check-ins?
Under such a scenario, Ms. Amer, the commission could grant a CCN in this case and ask the company to continue to come in regarding compliance with these units. I think the company has stated, and I have stated, that we are going to continue working towards compliance in 2045. But what would be unacceptable for the company is, under the scenario that you just stated, Ms. Amer, the commission have a finding that these resources would not be recoverable past 2045 should they still be used, even if they're still used and useful in serving New Mexico customers.
But the commission could be silent on that issue. Is that correct?
And I believe that goes to my first option, Ms. Amer, is the commission could grant us a CCN in this case.
And be silent on the exception ETA compliance issue. And if the commission did that, what would be the financial accounting risks involved with that for SPS? Would your answer that, and then I'll have another question.
Sorry, can you restate the question, Ms. Amer?
If the commission did option 1, which is line 5 through 7, page 48 of your rebuttal, one option is to approve the gains and Tolk CTGs without an exception and grant the CCN for both projects, reserving any adjudication of 2045 REA/ETA compliance for the future. What are the financial ramifications for SPS to such a decision?
Granting a CCN of these projects
Right.
would allow us to bill these projects and recover the costs of the projects from our customers in both jurisdictions, should both jurisdictions grant approval.
Right, but then the second part of that is reserving any adjudication of 2045 REA/ETA compliance for the future. That phrase, would that have any financial implications for SPS?
I believe that phrase just means that we are going to continue working towards 2045 compliance. And should there be an option for compliance in the future, the commission can evaluate that options and the financial consequences of that those options at that time.
So it wouldn't, how would it be a liability on SPS's accounting books? Because it's uncertain?
I don't know, Ms. Amer, and maybe I'm not understanding what you mean by what would be a liability. I'm not understanding your question.
There's some doubt as since you're reserving adjudication, which is what you state here, there's some doubt as to cost recovery in 2045?
Ms. Amer, it's my position that if the commission grants a CCN and it doesn't say anything else about recovery, that is an acceptable result for New Mexico, and reserving adjudicating 2045 compliance in the future is acceptable. And I believe we're going to have to do that anyway, whatever the result in this case is, because we are still working towards compliance with the statutory requirement in 2045.
Let's cut to the chase here, Miss Lees. Whose obligation do you believe that it would be to have future adjudication of the REA ETA compliance in the future? So, in other words, if under option one, does SPS just wait and see whether or not the commission has the inclination and the time in the future to bring you back on that? Or do you believe that SPS has some affirmative obligation to come forth before 2045 and get resolution of any outstanding REA ETA requirements?
Thank you for the question, Madam Hearing Examiner. It's my testimony that the company is responsible for bringing forward projects that continue to make progress towards the 2045 compliance, and to the best of their ability, while maintaining system reliability and preventing undue impact to customer bills, to bring forward solutions and portfolios that will meet RPS 45 requirements. And the commission, of course, has obligations under the statute as well. So 2045 compliance is a shared responsibility between utilities and the commission.
Thank you. Go ahead, Ms. Amer.
And how would a future commission measure compliance?
It would look at the portfolio that SPS has. It would look at the recs generated by that portfolio, and it would look at the resources on the system that meet the requirements of meet the definition of zero carbon resource under the statute.
But right now, gains and talc are CTGs. Are they zero carbon?
This application puts forward an analysis that shows that 363 megawatts of the gains CTG could be designated and should be designated as zero carbon resource.
But if under your option one, are you asking the commission to grant gains and talc without an exemption and designate them as zero carbon at the same time, or just be silent about whether or not they're zero carbon?
On page 48, my testimony says one option is to approve the gains and talc CTGs without an exception and grant the CCN request for both projects. It's silent on designation for zero carbon status.
So a future adjudication would have to determine whether or not gains and talc were zero carbon.
It could also examine alternatives for the gains and talc units. It could examine possible shortened lives for the units. Just as we were discussing before, I think there's a lot of options available to SPS and to the commission in adjudicating compliance in the future.
So just to be clear, your option one would also not make a determination on whether or not Gaines and Tolk are zero carbon now.
I think that's up to the commission, whether it would like to make that designation or not in selecting option one to go forward.
Okay, I would like to ask you more about the exceptions now. Do you agree that the commission is not allowed to exceed its statutory authority?
I agree with that, Ms. Amer.
And when you were assisting in preparing this application, did you consult with your lawyers about SPS's request for a determination that Gaines and Tolk should be determined to be zero carbon?
Yes, ma'am.
And did you consult with your lawyers about whether or not the commission had the authority to grant an exception from the REA 2045 carbon?
Yes, ma'am.
And did you find anywhere in the statute that the word exception is written?
May I look at the statute while I'm answering these questions? Thank you.
And look at the exact word, exception or exemption.
The exact words exception or exemption are not used in the statute, Ms. Amer. I think that's a matter of semantics. My testimony is that 6216(4)B and the requirements for the commission under that subsection give the commission authority to exercise such exceptions or exemptions or to take action if it is looking at a portfolio that is necessary to maintain system reliability and to prevent undue impact to customer bills, but is not compliant with the 2045 requirement or any of the requirements under the statute for that matter.
So I believe you're looking at, am I correct that you're looking at 6216(4)B 1 through 7?
And I'm referencing B2 and B3.
But isn't it correct that 1 through 7 contain different factors?
Yes, Ms. Amer, it's my testimony that subsection B provides the requirements the commission must take into consideration when administering the standards in the statute. And that it grants the commission authority to act if if compliance with the 2045 requirement or any of the other requirement would impact in a negative way the safety and reliability of the system or unreasonably impact customer bills.
Can you read to me the first line of B, 6216(4)B?
In administering the standards required by paragraphs 5 and 6 of subsection A of this section, the commission shall.
And is it correct that 5 and 6 reference the standards of 2040 and 2045?
That's correct.
But you just reading that sentence, does that sentence contain except or unless?
I don't see those words in that sentence, Ms. Amer. As I stated before, 6216(4)B 2 and 3 provide the commission the authority under the statute to administer the standards, but ensure in administering those standards that it is maintaining and the utility is maintaining system reliability and safety and preventing an undue impact to customer bills. And as Mr. Gable has demonstrated in his testimony, bringing forward a portfolio without gains and TOLC at this time does impact reliability on our system and does cause an undue impact to customer bills. And in fact, those impacts continue on into 2045. And Mr. Gable can discuss that modeling and when he's on the stand.
Do you agree, though, not as a lawyer, but just in your position as vice president, that there's a difference between a variance and an exception?
Objection.
Mr. Larson?
I have an objection to the question to the extent that it calls for a legal conclusion.
Ms. Amer?
I believe that vice presidents are in the position to decide whether to apply to a state agency for a variance, or if they choose to, an exception.
May I respond, Madam Hearing Examiner?
Yes, sir.
I believe the question was asking Ms. Lees to differentiate between the legal meaning of two terms, and therefore the question calls for a legal conclusion.
I will rephrase the question.
Ms. Amer?
Did SPS consider applying for a temporary variance under 62-16-4B?
And sorry, my understanding of a variance is how it's defined in commission rules. So I'm a little bit confused by the question, but as is in our application, the commission did consider applying for an exception, an exemption, a variance. I think this is semantics at this point, under 62-16-4B. And as laid out in option 3, we've laid out an option for the commission to grant that request and have a future check-in on whether that request is still justified or whether there's an alternative for these resources that is in the public interest.
I need a clarification for what you said. You said,
Sure.
as in our application, the economics did consider applying for an exception?
I don't think I said that. I said the company,
Commission.
the commission. Oh, I might have misstated. In our application, the company did request an exception, an exemption, a variance. I guess it's semantics at this point.
Okay.
Under 62-16-4. Thank you, Madam Hearing Examiner, if I had misspoken.
Thank you. Go ahead, Ms. Amer.
According to what you just said, you believe that it's semantics between the words exception and variance. Is that correct?
That was what my testimony was. I believe that 62-16-4B does give the commission authority to act in some way here in order for the company to bring forward this portfolio and to demonstrate that the portfolio maintains system reliability, and the alternative for a portfolio that doesn't include gains and TOLC does not maintain system reliability and prevents undue customer bills. And the alternative with a portfolio without gains and TOLC does not prevent undue impact to customer bills, and to act in a way that approves the portfolio, approves the resources, and exempts, accepts, or provides a variance to the requirements starting January 1st, 2045 under the statute.
Going back to 62-16-4B, there are 7 factors, and between 6 and 7, there's the word "and." Is that correct?
That's what the statute says. Yes, ma'am.
So that would, is it your opinion that would mean that the commission, in administering the standards required by paragraphs 5 and 6 of sub A of this section, the commission shall do all 7 because of the word "and"?
Objection.
Mr. Larson?
Ms. Amers asking Ms. Lees to engage in statutory interpretation. I think the question calls for a legal conclusion.
Ms. Amer?
Does the statute include a requirement for the commission to look at all 7?
Same objection.
Ms.
I don't-
Amer? Do you have,
I think that technical people who work for utilities have to read regulations and statutes, and they need to know what the word "and" means. And that it's not legal.
I believe as the parties are aware, certain deference is given with regard to the witnesses' interpretations of how the facts are interpreted by the legislation, rules, statutes that govern public utility regulation. And therefore, I'm going to overrule the objection, and you can answer if you know, Ms. Lees.
Ms. Amer, can you repeat the question, please?
Could the court reporter read it, please?
Basically, the question, do you believe that the statute includes a requirement for the commission to look at all 7 parts of 62-16-4B?
I believe that 62-16-4B lists the items that the commission shall take into consideration, and that the statute speaks for itself in how it characterizes those considerations and whether they're required.
Okay. I'm sorry. Anything further?
It's fine. No.
Very well. Okay, we're going to stop at this particular point. You will have 35 minutes remaining, Ms. Amer, when we come back from our recess. As previously indicated, the hearing will be recessed to allow the parties to observe the commission's special open meeting from 10 to 12 regarding the commission's new docketing system. I will add 45 minutes to that for luncheon break, and we will come back at 12:45 and resume the cross-examination of Ms. Lees. Thank you all very much.
Madam
And-
Hearing Examiner, I have one thing to just address
Yes,
for
sir.
everybody. So thank you, everybody. We'll break here just in a few minutes and have a recess. But I just want to reiterate this concept of the duty that hearing examiner Hurst and I have to make sure that the proceedings occur without any unnecessary delay or any kind of disruption to the order. So we've discussed this in our pre-hearings. I believe we discussed it a little bit yesterday, but all of us have a duty here to make sure that our questions and our answers are efficient and useful and meaningful. So just want everybody to keep in mind that as we go forward, let's make sure that we are making best use of our time. We don't have that many days left, and I would particularly just note that the applicant, the company, requested this on a short deadline. And we all have to make sure that we're, again, not delaying or causing the proceedings to move more slowly than they have to. So we'll be continuing to talk about this duty and the proceedings and making sure that everything is moving efficiently. If we had 4 weeks to do this hearing, maybe we would, but we don't. So again, it's just incumbent upon all of us to make sure that we're moving ahead thoroughly and as efficiently as possible. So thank you, everybody, for your attention.
Thank you, hearing examiner Schaefer. We are recessed until 12:45. Thank you.
Thank you.
Hey, so was Patrick telling me I was wasting their time? I think he was telling me to answer the question. Oh, yeah, I'm not really. Because Tom's already told her cut to the chase, right? So. Yeah. Answer the fucking question.
We can hear you, staff. Judy, you may want to mute.
Yeah.
Good afternoon.
Hello.
Yes, hearing examiner, could you just note my appearance when we start again?
I can.
Okay, thank you so much.
You're welcome. Okay, we have more people in the waiting room.
I'm ready when you are, Judge.
All right, Mr. Lee, thank you so much. Okay. Good afternoon. We are resuming our hearing in case number 25-00066. We've taken our break in our luncheon, and I see you have your hand up, Mr. Larson. Go ahead, sir.
Thank you, Madam Hearing Examiner. Just one update on the bench requests from yesterday. We're in the process of uploading those responses to those 4 items to Box now, so they should be coming in there in the very, very near future.
Very well. Thank you. Appreciate that. I'd like the record to reflect that we have a new participant wasn't with us this morning, Miss Sir for Sierra Club is with us this afternoon. I'd also like to indicate that SPS filed its supplemental notice of affidavit of mailing. If you'll recall, yesterday I made inquiry about the right-of-way requirement to send to the application and notice sent to the libraries. And today, SPS gave notice that its application and pre-filed testimonies were sent via FedEx to the libraries in the cities of Hobbs, Lovington, and Carlsbad, as represented in Mr. Jones's affidavit. Okay, very well. We will resume. Okay. Let's see. Okay. Got to have more information than Zoom user. In the waiting room. Gonna have to identify yourself more than that.
Madam Hearing Examiner, we're going to go check in the witness room to see if they can change the identifier, because it may be Miss Lee's.
You think that's who it is, Mr. Larson?
I do, and it
Okay,
sounds
I'll
like
take a chance.
it sounds like IT may be in there with her. So that's probably not a good sign, but that's the status.
Sign off and rejoin.
There she is.
I'm not sure what I did, but all of a sudden it worked.
Okay, Miss Lees, is that you?
It is, Madam Hearing Examiner. My apologies. I was in the waiting room, but I don't know why I wasn't entering, but now I'm here.
Okay. Well, any unidentified? I'm afraid it's AI trying to get into the hearing.
I
So
understand.
when it just said Zoom user, I wasn't going to let it in, but your attorney decided that it was probably you, so I said okay. All right. Okay. And you haven't forgot about me, have you, Miss Lees, about that the rate case exhibit to your direct testimony?
No, Madam Hearing Examiner, and I believe my attorneys have been working on bench request responses, and Mr.
Okay.
Larson can update you on that.
Okay. I just didn't see it in the info share, and it's not my case, but I wanted to look at that exhibit, your exhibit 2,
Okay.
to the rate case, to your direct testimony, because I think it had jurisdictional allocations.
Okay.
Okay. And like I say, I couldn't find it in the info share.
Okay.
Okay.
Well, Mr. Larson, if that isn't being worked on, can you ask someone to start working on that?
Yeah, we are actively working on that, Madam Hearing Examiner. And
Awesome.
I'll give you an update as soon as I have.
Okay, great. Very well. Okay, now I think we're ready to resume our cross-examination for Miss Lees. And Miss Amer, I believe when we had a break, you had 35 minutes left. All right.
It looks like Miss Amer's muted.
We cannot hear you, Miss Amer. Ammer.
That is correct. You said I had 35 more minutes.
Yep. You're
And
gonna need to speak up a little bit.
can you hear me now?
I can hear you. I can just be bold. And go ahead.
Okay. I'd like to ask who at SPS or Excel made the decision not to pursue an exception to the winter PRM increase to 36%.
I don't agree that anyone at Excel decided not to pursue an exception. Indeed, it's my understanding that we appealed that requirement at FERC, and Mr. Cooley has more details on that.
Okay, so who, at what point in time did you make that appeal?
Mr. Cooley knows the details of the appeal, and he's the better witness to ask those questions of.
And did FERC deny that?
Mr. Cooley knows the details of the FERC decision. I don't believe they denied it, but I think there were some conditions in there, and Mr. Cooley's going to have to answer questions regarding that decision.
Do you know whether the notification of the increase in the winter PRM was before or after issuance of the 2024 RFP?
I am not clear on the exact timing, Miss Amer. I believe we incorporated an expected winter PRM into the RFP requirements, but Mr. Gable will be able to provide you the exact details on that.
Okay. Now I'm going to move on to your rebuttal testimony, page 29, where you characterize Mr. Zigich's statement that SPS instructed its RFP evaluation team to effectively disregard New Mexico law as a, quote, gross misunderstanding. Is that correct?
My testimony says Zigich's position is either a gross misunderstanding of the bid evaluation report or an unfounded attack on the integrity of SPS's modeling process.
And you assert that SPS analyzed zero carbon compliance after the portfolio was selected, correct?
SPS first analyzed, modeled the portfolio for a multi-jurisdictional baseline plus the RPS compliant projects. It then took a look at what a portfolio would look like if it was RPS 30 compliant. The results of that look were that it would be a much larger build, that the cost impact to customers would be significant, and it was not a cost-effective portfolio, and there would be significant curtailment risks. There were not sufficient bids in the RFP to evaluate what a portfolio would look like to serve system needs, meet our reliability requirements, serve other system needs in a fully compliant manner with the 2045 requirement. So once SPS knew that it would need to bring forward a portfolio that included gains and tolk CTGs, it did the analysis to demonstrate what the impact to reliability would be and what the impact to customer bills would be should those resources be denied.
But just to make it clear, the zero carbon compliance was put into the bid selection after the portfolio had been selected. Is that correct?
Those analyses were done once it was apparent that we couldn't provide a portfolio through this RFP that was fully 2045 compliant.
But they weren't, the zero carbon compliance wasn't done at the outset. Is that correct?
That's correct, because SPS is charged through the IRP rule and through the consented to action plan to model the most reliable, cost-effective portfolio among available bids. There were not sufficient bids available in order to model a fully 2045 compliant portfolio.
Well, I agree with what you're saying about the IRP rule and statute. But don't you agree that the zero carbon compliance is another statute and you can actually implement them at the same time?
I think the results of the RFP and the modeling we did shows that it was not possible to implement the 2045 compliance at the same time as providing the most reliable, cost-effective portfolio among the available bids in the RFP.
Do you agree that by waiting to analyze compliance until after selection of the portfolio, the model selected resources based upon economics and reliability without the constraint of the 2045 zero carbon requirement?
I'm sorry, Ms. Aber, can you repeat the question?
Yes. By waiting to analyze 2045 zero carbon compliance until after selection of the portfolio, isn't it true the model then selected resources based purely on economics and reliability without regard to the 2045 zero carbon requirement?
Mr. Gable.
Go ahead, Ms. Lees. I'm sorry.
Mr. Gable can answer questions regarding how the model selected resources, Ms. Amer.
Was the 2045 zero carbon requirement a constraint on the bid selection?
Mr. Gable can talk about the constraints and parameters of the modeling, Ms. Amer.
Isn't Mr. Zigich substantially correct that after the initial selection process, SPS ignored the 2045 mandate, thereby prejudicing the outcome in favor of gas plants?
I categorically disagree with that assertion.
Okay.
Why?
Because the company, when it understood from the available bids that it would not be able to build a portfolio that was 2045 compliant, just from the available bids, setting aside reliability and cost effectiveness and affordability for customers, the company understood that it needed to start looking at what the impact to customers would be should the gains and Tolk units not move forward. And it did the analyses that under the statute, the commission needs in order to effectuate its own responsibilities under the statute, so that the commission could understand what the impact to customers would be should gains in Tolk not move forward from a reliability standpoint and from an undue impact to customer bill standpoint. So we did the analysis in order to provide the information that the commission needs in order to exercise its responsibilities under subsection D of the statute.
Thank you. Go ahead, Ms. Amer.
Isn't it true that when there's several different portions of a statute, you have to read them together?
I agree that you need to read the statute to effectuate the statute as a whole. And a reading of the statute that would prohibit the commission from granting an exception under the considerations that it must take into account under subsection B would render that authority under subsection B meaningless.
And I do want to come back to subsection B. But I do want to move on to Mr. Zigich's engineering concern and page 58 of your rebuttal. And where you address Mr. Zigich's concerns regarding the verification of methane reductions, stating that a, quote, perpetual revisitation of a designation is a time-consuming effort. Is that your testimony?
Yes, my testimony on page 58, starting at line 15, says a perpetual revisitation of a designation is a time-consuming effort that creates uncertainty with little commensurate benefit. And then I go on the next page to discuss a pathway forward should the commission want such verification.
But isn't it true that SPS's position about zero carbon is purely dependent upon the actions of unregulated third parties?
The zero carbon designation analysis that Mr. Oss puts forward and can speak in more detail about than I can takes into account the electrification plans of multiple SPS customers.
Correct. And those SPS customers are oil and gas customers, some, I presume,
Yes, ma'am.
and they are unregulated by the New Mexico Public Regulation Commission, correct?
That's correct. And I think that speaks to the importance of this portfolio, that it enables unregulated entities, unregulated by the commission, entities that are unregulated by the commission, to electrify their commission. And in fact, under subsection B, the commission is charged with considering whether a portfolio would have the effect of increasing emissions from those parties that are not regulated by the commission. And this portfolio enables the electrification of those entities.
Yes, it might enable it, but SPS has no authority to stop them from not choosing to electrify, right?
It is our customer's choice whether they want to connect to our system or not. We have heard from multiple customers that they do want to connect to our system and electrify their processes. And those customers participated in Mr. Oss's study, and he can speak to that analysis.
But if those oil and gas customers chose to electrify another way and due to changing market conditions, SPS would have no authority to stop them.
Our customers' decisions are their own, Ms. Amer.
And likewise, the commission would have no authority to either stop them or have them electrify with SPS. Is that correct?
That's correct, Ms. Amer, but certainly the commission has authority today to approve the portfolio we put forward, which would enable the connection of those customers who seek to electrify. And by not approving the resources in the portfolio, in particular gains, SPS would not be able to meet the growth on its system, which includes electrification growth.
But according to the requested relief in your application, the Gaines County gas plant would retain its zero carbon designation permanently, regardless of whether or not that customer did connect to SPS's system or decided to perhaps put on an on-site diesel generator. Isn't that correct? It would be a permanent zero carbon designation.
My testimony is that the statute provides an analysis that the utility must do in order to demonstrate a unit or megawatts should be designated as zero carbon. I do put forward in my testimony a recommendation, should the commission feel that verification is possible, that there's a pathway to do that.
Doesn't this validate Mr. Zigage's concern that the commission, if they granted SPS's request, would be issuing a non-revocable finding based upon emissions reductions in the future that it cannot enforce?
I don't know that this does validate that, Ms. Amer.
Well, do you agree that it cannot enforce against those other customers? I think we already said that. Is that correct?
It's my testimony, Ms. Amer, that I don't believe the commission has jurisdictional authority over customers in that manner.
And it's SPS's request that it be a non-revocable finding of permanent zero carbon designation. Correct?
Yes, and in my testimony, I say if the commission is not comfortable with that, it should leave the door open and allow the company to work with its customers in order to bring forward a verification process for the commission's consideration.
All right. Now I'd like to move on to the issue of split systems. And on page 71 of your rebuttal, are you there?
I am.
You claim that by denying the gas units, gains and toll, that would lead to a split system costing New Mexico customers an incremental 5.5 billion. Is that correct?
That is my testimony on page 71, lines starting at line 14, that the projected that resources would likely be direct assigned to New Mexico given the circumstances and would be projected to result in an incremental cost impact of 5.5 billion on a net present value basis as compared to the final preferred portfolio.
But isn't it true there already is a split system? Because you just said New Mexico customers get assigned the 100% of the cost of certain renewables.
Certainly,
that looks like a split system, right?
Certainly resources that are selected only but for the requirements in the RPS are direct assigned to New Mexico. I have serious concerns about fully splitting the system and being in a situation where we are only acquiring resources for New Mexico and only acquiring resources for Texas and furthering that division.
So the division, though, does exist, right?
There are limited number of resources, one in this portfolio that we are asking for approval for meeting RPS compliance purposes, yes.
Mhm.
And there are a limited number of resources for which we have approval in one jurisdiction and not the other. My concern is furthering that. It will have significant cost impacts on New Mexico customers. And in my opinion, it is not in the public interest to do so.
I understand your concern. But if the system continues in that manner of a split system, does it make sense to SPS to have the thermal units be recovered by Texas and the renewables be cost recovery to New Mexico?
We do have to evaluate that if that is the policy decision of the state to have us start splitting the system in that manner. We would have to evaluate what our options are.
Isn't it true that the 5.5 billion figure that you say it would cost New Mexico assumes that the only alternative is renewables and storage?
Mr. Gable can talk about the modeling that went into what the modeling selects, excuse me. Should we need to split the system, and should the commission deny Gaines and Tolk? And Mr. Trowbridge can discuss the calculations he did on the cost impact to New Mexico customers.
Ms. Lees, this is Hearing Examiner Schaefer. May I ask you a question?
Yes, sir.
Your direct testimony mentions modeling 22 times.
Yes,
And
sir.
attached to that testimony is a document that mentions modeling 749 times.
Yes, sir.
Your rebuttal testimony mentions modeling 26 times.
Mm-hmm.
And in
Yes, sir.
addition to mentioning it, those testimonies go into quite amount of detail regarding modeling. And I feel that when the parties or the commission asks you about modeling, for example, we are told that another witness is preferable.
Yes, sir. And that
So
witness.
my question is, why did you present such voluminous amounts of testimony on modeling and routinely defer questions to another witness?
Yes, sir. The IRP process and the process that the commission, or the company needs to follow in order to bring forward resources includes the integrated resource plan and includes the RFP process. Those processes include an intense amount of modeling, using specific tools, the Encompass model specifically, in order to model different scenarios with different technologies and different load forecasts in the IRP process, and then to select resources according to the constraints in the RFP. I do not conduct that modeling. My job as RVP is to present the case, and that modeling is foundational to the case. And it certainly informs the requests in this case and the policy decisions that I talk about in this case. And I talk about the modeling results at a very high level, but I feel that Mr. Gable, who is the subject matter expert in the modeling done in order to select resources through the RFP and to provide the analysis needed to demonstrate what the impacts are that pertain to the exceptions. He is the one that does the modeling, that understands the modeling, that designs the modeling, and I feel more comfortable having him answer questions as I address modeling on a very high level, as it is foundational to the resource planning processes that the company took. Thank you for the question.
Sure. Let's just explore this for a minute further, because I think it really pertains to the fiduciary duties of us here with respect to this hearing. And I'll ask you, don't you think that if you mention modeling 22 times in your direct and 26 times in the rebuttal, that it signals to the parties, the intervener, staff, the commission, that the witness is prepared to answer certain amount of questions with respect to modeling?
Certainly, I would think that if I hadn't continually said in my testimony and rebuttal testimony that Mr. Gable and Mr. Trowbridge, but Mr. Gable in particular, can discuss the details of the modeling. I think my testimony mentions that he can go into those details many times, as I've said, on the stand. And that reinforces that I am presenting this from a high level for the company, and that I have a subject matter expert that can discuss how that was done and what the results mean in a more granular manner for the commission in order to get those answers that the commission desires.
I'll just say that the consequence of this, and maybe you have intuited this or seen this, is that parties, including staff, including the commission, including the hearing examiners, do a lot of preparation for each witness. And so yesterday and today, a lot of preparation that has gone into your testimony and cross-examination has been to some extent futile, because the questions are not able to be answered. So I just want to remind the applicant and the parties that there is a duty that we all have for efficient and meaningful cross-examination. And so if a witness provides direct or rebuttal testimony with significant mentions of certain matters or concerns, that's going to create an investment and a time, whether preparing for the hearing or during the hearing, that is spent on these questions. And then when you can't answer them, that is a lot of time and investment that doesn't really move the hearing forward. So I would just recommend that we try not to cause a lot of this time and investment that for a witness that can't answer the questions. Please proceed, Ms. Amer.
Thank you. Yes, Ms. Lees, I'm actually not asking about the modeling itself. I'm asking about the result, which is that it resulted in a $5.5 billion cost to New Mexico.
And Ms. Amer, I'm so sorry. I have completely forgotten what the original question was.
So,
yeah.
On page 71 of your rebuttal, you claim that denying the gas units, Tolk and Keynes, would lead to a split system, costing New Mexico customers an incremental $5.5 billion. My question was, this $5.5 billion figure assumes that is the only alternative to replace Gaines and Tolk is a portfolio of renewables and storage.
I believe that modeling included technologies available today, Ms. Amer.
But isn't it true that if Gaines and Tolk were not approved, it could be replaced by a variety of renewables, storage, other PPAs, other items that would comply with the REA?
I disagree with that statement as it pertains to the bids received in this RFP. There are not sufficient amount of bids in order to replace Gaines and Tolk with storage or renewable energy in an amount that's sufficient to meet our system needs.
Did SPS consider replacing them with PPAs?
Again, our RFP was an all source RFP. We received bids, not only self-build bids, we also received bids from independent power producers. We have another case pending in front of the commission on PPAs, and those are all the bids considered and what our options were to replace Gaines and Tolk are inclusive of those PPAs. So again, we didn't have sufficient amount of options in this RFP inclusive of PPAs to replace Gaines and Tolk.
Well, but isn't it true that you asked for bids for combustion turbines and you did not ask for bids for these combined cycle turbines?
I disagree, Ms. Amer. We issued a all source RFP and did not state any preference for technologies one way or the other.
Mr. Zigic suggested an alternative approach, approving the CCNs for the Gaines and Tolk so that their depreciable lives are aligned with the 2045 deadline, which would effectively mitigate the stranded asset risk to New Mexico customers. Did SPS calculate the cost of that specific proposal?
I believe Mr. Gable's rebuttal testimony provides testimony on what that shortened life would look like for the assets.
I'm not referring to a 20-year depreciable life I'm referring to a 20 years for New Mexico, but 40 years for Texas. Was that calculated?
I guess my answer is the same. I believe Mr. Gable presents some testimony on that in his rebuttal.
If the commission were to adopt Mr. Zigic's recommendation to require an action plan for a zero carbon baseload capacity like nuclear or long-term storage by 2045, wouldn't that avoid the split system scenario you described?
I don't know, Ms. Amer, and I'm a little lost on the recommendation of Mr. Zigic that you're referring to.
It was in his direct, but I do not want to spend time finding that. That was his recommendation for a zero carbon baseload capacity by 2045 for the whole system. Aren't there other ways to have accomplished what SPS wanted other than the 2 gas plants that would not be able to be used in 2045?
In terms of options that we had in this RFP, there were not sufficient amount of bids to supplant the need for Gaines and Tolk. But I do want to make clear that SPS, it's not my testimony, it's not SPS's position that we will stop working towards making continuous progress towards the 2045 requirement. In fact, WRA witness Ms. Weller has a really good recommendation that we develop an RFP or a study for zero carbon resources that may be available in the New Mexico service territory. I think that's a really good recommendation, and we should discuss a study or RFP like that in this next IRP, get stakeholder input on such a study and evaluate the parameters of that and evaluate that and issue it as part of the next IRP.
In terms, you keep saying bids received, but the bidder was Xcel, isn't that correct?
A bidder was Xcel Energy. We also had other bidders bid into this RFP as well. It was an all source RFP. that allowed for multiple ownership arrangements to bid in.
Well, SPS is a subsidiary of XL. So, and I think many of these projects are self-built. So couldn't XL have submitted different bids?
I don't know whether Excel could have submitted different bids or not. Ms. Amer, I wasn't on the bid development team. You'll have to talk to Mr. Gertz or Mr. Lytle about the actions taken by the bid development team.
And isn't it true when you say no bids were submitted, it's like saying I didn't submit the bids, because SPS and XL are the same.
I don't agree with that, Ms. Amer. The RFP was open to bidders, not just Xcel Energy. And SPS could only evaluate the bids that it received, both by the company and by other bidders. My testimony is that of all the bids received, it is my understanding that there was not sufficient bids to build a portfolio that would be compliant with the 2045 requirement and meet our system needs.
As you said, it was an all-source RFP, so XL could have submitted a bid for nuclear or long-term duration storage. Isn't that correct?
I don't know whether it could or could not have. I am not familiar with what the bid evaluation, or excuse me, the bid development team, what their abilities were, or whether they had a project in development that would have met the requirements in the RFP that they could have submitted into the bid like that, Ms. Amer.
Okay. Moving on. How much more time do I have?
4 minutes.
How many? 1?
4.
4. If I need to, I would request that I take 5 minutes from Mr. Gable. If you would allow us to do that.
Go ahead.
Thank you. On page 57 of your rebuttal, you dispute Mr. Zigich's testimony that New Mexico environmental rules already mandate the methane reductions that you would like to claim credit for.
I do not dispute that. I do not dispute that the New Mexico Environment Department has reduction requirements.
You did admit in response to staff data request 5-3 that SPS's customer agreements do not contain specific commitments to reduce methane emissions. Is that correct?
I need to look at that discovery response, Ms. Amer.
Do you know?
I can look for it. I don't know if I have it in the hearing exhibits, but if you tell me what exhibit it is, I can look at it.
So right now you're saying you do not know if the SPS customer agreements contain specific commitments that they signed to reduce methane emissions.
Oh, my apologies, Ms. Amer. I thought you were asking me to verify a discovery request language.
Well, that was the answer, but I want to know if those customer agreements contain specific commitments to reduce methane emissions.
It's my understanding that our electric service agreements and our form electric service agreement doesn't contain such provisions, Ms. Amer. I'm not sure what you mean by other agreements, but
does SPS have anything in writing from its oil and gas customers where they commit to a specific commitment to reduce methane emissions?
I don't believe we have a commitment from all of our oil and gas customers in writing that they will reduce their methane emissions. But we do have our load interconnection requests from customers in order for them to electrify their processes. And that's what we understand is their interest in electrifying.
That is their interest, but not their commitment. Is that correct?
I can't speak to our customers, whether they have what their commitments are as broadly, Ms. Amer.
If customers are required by state law to reduce methane regardless of whether or not SPS builds gains in talc, isn't Mr. Zijic correct that the cause of the reduction are the New Mexico environmental laws, not your specific gas turbine?
Ms. Amer, the question is a little confusing to me because I understand that the New Mexico laws require our customers to reduce methane emissions. Our customers cannot do that, cannot electrify their processes without available electricity. And this portfolio, inclusive of the gains CTG and the talc CTG, provides the electricity necessary for our customers who are interested in electrifying and have put in load interconnection requests that will be addressed by this portfolio to electrify.
But the zero carbon requirement, the reduction in methane has to be caused by what SPS does in terms of building the plants. And so I'm asking about the cause of the reduction. How do we know what the cause of the reduction in methane is here?
My testimony is that in order to electrify load, you need available electricity in order to do that. And available electricity for these companies, in order to electrify, will reduce methane emissions.
But isn't it true that the cause of the reduction are the state laws?
The state laws mandate reduction. I think if you're looking for what effectuates that reduction, it is available electricity for electrification of those processes.
Okay, back to 16.4.
I'm sorry, can you state that again? I can barely hear you. Back to
62.16.4 and the 7 factors that were listed there. Are there other ways for the commission to effectuate any or all of those factors other than granting an exception to the 2045 RPS requirement of zero carbon?
I don't know, Ms. Amer. I think what the subsection B of 62.16.4 does is provides the commission with the responsibility that in administering the requirements under this statute, they have to take certain consequences into consideration and prevent those consequences. And I think it gives the commission flexibility to prevent those consequences. And it is the commission's authority and decision on how to exercise that flexibility and that delegation of authority under the statute.
So there may be other ways to ensure those protections other than granting an exception.
I don't know of other ways at this time, Ms. Amer.
Has the commission ever granted an exception to the zero carbon requirement of the REA?
Not that I'm aware of, Ms. Amer.
If the commission decided to grant such an exception, would that set a precedent for other utilities to request exceptions?
I suppose it could. I think that the ability to request exceptions is provided in the statute.
I know. And do you agree that about 6216.5, which sets forth the reasonable cost threshold? It's not. It's 6216.4E. And it's pretty long, but it says and I'm going to paraphrase it, if the utility is going to exceed the reasonable cost threshold, and now I'm quoting, the public utility shall not be required to incur that cost, provided that the existence of this condition excusing performance in any given year shall not operate to delay compliance with the renewable portfolio standard in subsequent years. Do you agree that that creates an exception?
Seymour, I'm just going to take a minute to read the statute. Sorry. I agree that this statute provides the utility kind of a ceiling of cost for a renewable energy resource. And if the resource is above that threshold, then the utility is not required to bring it forward for approval. Provided that sorry, I'm working through, you're asking me to interpret the statute that I hadn't been thinking about before, so I'm doing the best I can.
If this is also an exception.
I've always looked at the subsection E as guidance to the utility in terms that if it's seeing a renewable energy project that's above a certain cost threshold, that it is not required to bring it forward in order to meet compliance. Sorry, Ms. Amer, I'm not trying to be evasive. I've just never really thought about it, whether it's an exception or not before you've asked me this question today.
I think we can agree it specifically excuses performance in any given year, because it says that.
That's what the statute says, yes.
Okay, you're at 7 minutes past, Miss Amer. How much farther do you want to go?
I'll ask one more question. Isn't it true that it also says it doesn't operate to delay compliance with renewable portfolio standard in subsequent years?
Ms. Amer, the language of the statute says what the language of the statute says. Those words are in the statute.
And it's true that that section reads differently than B. Is that correct?
That is a different section than section B, Ms. Amer, yes.
Section B doesn't use the word excuse performance.
No, it does not.
Okay, I have no more questions.
Okay, so that's -7, you said, Ms. Amer, from staff for Mr. Gable, right?
Yes, thank you.
Okay, very well. I believe that concludes the cross-examination from the parties. Hearing Examiner Schaefer, did you have questions for Ms. Lees?
Yes, I do. Thank you, Hearing Examiner Hurst. Ms. Lees, thank you again for taking the time to be with us. And one of the questions I wanted to ask you is you've often used this adjective unacceptable when describing the possibility of having these resources not approved by the commission. Could you tell us what you mean by unacceptable?
In terms of the resources, not the gains and Tolk resources specifically not being approved, I am very concerned that would cause reliability issues. I don't think it's acceptable to have a portfolio that doesn't meet the reliability needs of the company. And I'm concerned that a decision like that is a policy decision that SPS needs to start planning the New Mexico system separate from the Texas system. And that consequence has significant impacts on customer bills and the affordability of the system. And I don't think that that would be acceptable for customers to face that cost impact. I think it's in the public interest and in the best interest of our customers for us to plan the system as a whole. And we don't have sufficient bids to replace the gains and Tolk resources in this portfolio in a manner that would maintain system reliability and prevent that impact to customer bills.
The application presents certain resources for which the company is asking authorization from the commission. And I'm just wondering if you can explain a little bit why or how these resources seem to have no alternative. And maybe you can correct me if I'm misunderstanding the application or the process, but maybe for the benefit of all of us here at the commission or the parties involved, explain maybe my perception that this seems to be a very take it or leave it application, that there are no sort of alternatives to meet the demand of customers as well as the demands of safety and reliability, that this seems to be the only option.
Yeah, thank you, Hearing Examiner Schaefer. The company is required to follow the processes required under the statute and required by commission rule. So the Renewable Energy Act does require that any project that will help meet the renewable portfolio standard requirement must be competitively procured. And the IRP rule requires that if the utility is going to seek projects to meet its statement of need under the IRP, that it must do so through a competitive procurement process. SPS followed those rules. It issued an RFP and as broadly as possible, so not to limit the options that we had. I'll also note that SPS is a member of the Southwest Power Pool, which studies and has processes to study the interconnection of generation. And any new generation that is interconnecting to the SPS system that is not interconnecting at a point of interconnection as surplus generation must go through that DICES process. Now, that's very high level. Mr. Cooley can speak to the specifics of that process and those requirements, but we have a process we have to follow in New Mexico to issue competitive procurements. And as a member of the STP, we also need to make sure that in accepting bids through that competitive procurement, that we're accepting bids that have sufficiently moved through the SPP process and has been studied sufficiently so that we know that these resources can get built within the resource acquisition period, and so that we have a good understanding of what those costs are associated with interconnecting the generation. So in that competitive procurement process, we designed it so it was as broad as possible, so we could capture as many bids as we possibly could. And the reality is the number of bids received that we could model and select from were limited to the point that we didn't have sufficient bids to model and bring forward a portfolio that was fully RPS compliant for the 2045 requirements. But we have to operate within those rules that the state and the commission have in terms of how we competitively procure resources. And that's what the company did.
So there was no ability whatsoever to consider an alternative arrangement of generating facilities or transmission infrastructure to satisfy the demands of the Southwest Power Pool and load safety and reliability on the New Mexico side.
Well, we've issued another RFP, right? So we've issued another competitive procurement because we still have needs that are not being met by this portfolio. So I do want to say, I think we're still exercising our options and trying to meet these needs. But at the same time, we have some very serious time constraints, and issuing an additional RFP before we bring forward a portfolio or taking a second look may not have been, frankly, found to be competitive by the IM, but also would have just further delayed and further increased the time pressures we have here in order to get approvals of resources, especially those resources that are helping us meet our PRM requirements earlier on in the resource acquisition period, and those resources that we need to start construction for to capture production tax credit benefits for customers.
Thank you, Ms. Lees. That's all the questions I had.
Thank you, Hearing Examiner Schaefer.
Thank you, sir. Ms. Lees, I've got a few questions that I'd like to ask you. And since I have I just want to start out with the table header on page 3 of your rebuttal testimony. Table ZEL-2.
Yes. Madam
Should that be a
Hearing Examiner?
rebuttal and not direct?
It should be, Madam Hearing Examiner.
Okay. Just want to make sure you're not referring back in the rebuttal to the direct.
Thank you, Madam Hearing Examiner.
Okay, so as far as what SPS has requested in this particular case and the options that SPS has proposed and other parties have proposed, in reading your testimony, it seems to me SPS would like, to the extent that it can get from the commission, definitive determinations on its requests, preferably in the affirmative, but even if they aren't in the affirmative, SPS is requesting that the commission not defer any actions or any of SPS's proposal. Is that correct?
In a holistic way, there's a lot of requests in the case, Madam Hearing Examiner. So in a holistic way, we're asking the commission to to make determinations on our requests as enumerated. I think there's a couple that I've said in my rebuttal. If the commission decides to make those decisions further down the road, it wouldn't be detrimental to building these resources. I think, anyway, I'll stop there, but.
Okay, and I was just, I had marked on page 7 of your rebuttal at line 16 through 17, and you say the commission should avoid deferring SPS proposals to future cases. The time for decisions with a robust record is now.
Yes, Madam Hearing Examiner, I'm referring there to our request of approval for these resources.
Ms. Lees, is it part of SPS's strategy to include several requests at any given time? To not only maximize what it can get out of any particular application, but also potentially so that if you get any deferrals, that particular action has an opportunity to get looked at or litigated in a different case?
It's SPS's strategy to include proposals and requests in the case to meet the needs of the case. So in this case, it's the need for more resources, and so that the company can have sufficient regulatory certainty moving forward with those approvals.
Well, again, I'm thinking about time for action is now, not deferral, but yet in a case that we were involved in last year, I think it 24-270, your FPPCAC case. I mean, you made a lot of requests in that case too. That were in addition to the FPPCAC itself. That ultimately, as part of the stipulation, those issues were agreed to be deferred to other cases, right?
Oftentimes in settlement discussions, we'll agree to defer certain issues so that we can come to a constructive result in the settlement for all parties. It's part of the give and take, ma'am.
And part of the track, the procedural track that the commission set up, as agreed to by the parties, in this case, was the opportunity to reach a settlement stipulation on issues, particularly the gains plan. Isn't that true?
Yes, ma'am. The commission did set up a procedure in order for all parties to meet and discuss settlement in this case.
And there wasn't any stipulation filed in this case, right?
That's correct, ma'am. The SPS and the parties met multiple times and had multiple conversations about settlement and were not able to agree on terms.
I'd like to go ahead and look at page 10 of your rebuttal testimony and the questions posed at line 12. In your opinion, do the party witnesses accurately capture or understand the interaction of the CCNs requested here with the 2023 IRP that preceded this filing. And you begin your answer on line 15 with note. That's your question in the beginning of your answer?
That's correct, ma'am.
What do you mean by interaction of CCNs?
So what I'm talking about, the interaction of the CCNs with the IRP, I'm talking about the requirement that SPS must follow in the IRP process to go through the facilitated stakeholder process. And through that engagement, put forward an action plan and a statement of need, and to the best of SPS and stakeholders' ability to put forward a consented to action plan and statement of need. And once the commission accepts that IRP, it is then under the IRP rule, then the utility can go forward and issue an RFP for any resources needed to meet the statement of need. And the SPS, it's our understanding that we need to issue that RFP and take actions that are consistent with the action plan that was developed in the IRP and consented to by all the parties. And that the result of taking those actions in the action plan and issuing the RFP is the CCN. And it's my position that many of the parties' positions in this case should have been discussed in that IRP process and in the stakeholder process, so that in following the action plan and designing the RFP in accordance with the action plan consented to by the parties, SPS could have effectuated some of those items ahead of issuing the RFP and going through the lengthy process of the RFP and then filing for the CCNs.
Further on page 11, and still answering that question, you say, referring to the 2023 IRP, it provided a portfolio-based framework based on modeling in which multiple generic resource types, in paren with generic pricing, in paren, contribute distinct and complementary operational attributes that together produce a least cost and reliable system plan. That framework, in turn, provides the baseline structure through which actual resources with actual bid prices are assessed to determine the optimal portfolio to serve SPS's customers. That's your testimony, right?
That's correct, ma'am.
So that's SPS's view of what the IRP does, and then what subsequent actions in reliance on the RFP do going forward.
It's SPS's position that we do the modeling high level described in my testimony in the IRP, which informs the action plan that's developed by the company and the stakeholders, and that SPS must follow that action plan in issuing the RFP and selecting resources.
Right, but this is SPS's view of the lens with how you think the staff and the interveners and the commission itself needs to view the plan you're offering.
It is, Madam Hearing Examiner, because if we are required to put forward an integrated resource plan and required to go through the facilitated stakeholder process, required to try to the best of our ability to come up with a consented to action plan and statement of need. I'm not sure what the purpose of that process, which SPS, by the way, found very valuable in going forward with the RFP and these CCNs. I'm not sure what the purpose of that process is. If we can't depend on the consented to action plan and follow that plan as we go further through the rule requirements and issuing an RFP and then eventually filing a CCN.
Okay, so two things from that. Your testimony suggests that's not the lens you think that staff and the parties looked at in developing their testimony in this case, is it?
Madam Hearing Examiner, I think the requests that I'm referring to here, I think, are those requests that are or those positions that should have been more fully discussed and considered at the outset of this process in the IRP rather than being discussed in a litigated case after that IRP process.
Right.
So I guess
so
if
that's the second part.
Okay.
I'm
maybe
still on the first part.
Sorry,
Yeah.
and maybe I'm
No,
not understanding it.
Okay.
Well,
I think I understand what SPS thinks is the appropriate chronology and foundation for the commission to evaluate. Your testimony seems to suggest that the party witnesses don't understand the interaction between the IRP and the subsequent actions that SPS took based upon the IRP process. Is that correct?
I think that's correct to the extent that parties are bringing forward positions that SPS believes should have been brought forward in the IRP so that it could have shaped the actions we took afterwards.
Okay, so your answer is no, they don't follow our understanding of how the process is supposed to work, and I can identify that they don't follow the process because the suggestions they make should have been made in the IRP. Is that your testimony?
Yes, ma'am. And I also think, you know, to the extent on the lines that you had me read, that there's a difference between the modeling we do in the IRP and the modeling we do in the RFP. And so.
Okay, no, I get that. Okay, I need you to clarify something on page 14 of your testimony. And you are answering the question posed at page 13, line 13, although staff recommends rejection of the Gaines and Tolk combustion turbine generators, also known as CTGs, the staff recognize the need for resources with attributes similar to Gaines and Tolk CTGs. So you begin your answer with yes on line 16, and then you go on to page 17, or not page 17, page 14, and you say, let's see, I don't want to start down too far. Okay, at line 5. Staff also does not dispute that SPS must comply with the Southwest Power Pool's PRM requirements in existence today. By accepting those requirements, staff implicitly accepts the need for the resources that provide accredited dispatchable capacity, which SPS cannot meet without the thermal generation in this portfolio. Finally, although staff has had access to all bids provided to SPS in the solicitation, it does not identify or suggest that SPS could have identified an alternative portfolio using the actual bid, project bids in the RFP. And then it goes on. So that's your testimony, right? You say staff didn't provide any alternative.
I did not identify any alternatives that staff provided,
Okay.
Madam Hearing
So,
Examiner.
okay. So then you go down to line 13 and you say, even if staff need not have provided such an alternative portfolio, the analysis demonstrates that alternative portfolios would not meet the resource needs of the system. That's your testimony?
Yes, ma'am, and that refers to the alternative portfolios presented by Mr. Gable.
Okay, so my question is, if they didn't provide any alternative portfolio, and you're saying they need not have even provided one, then how do you know, if they didn't suggest anything, that something they suggested wouldn't have met the needs of the system?
My testimony here is that we provided all the bids to parties in this case. No party, including staff, came up with an alternative portfolio. And even if they aren't required to come up with an alternative portfolio, we don't have options here for an alternative portfolio that would meet the system needs. We didn't have sufficient resources bid into the RFP that would have allowed us to build a 2045 compliant portfolio or to build a portfolio to meet our system needs without selecting gains and Polk.
So basically, then, if I understand your testimony, there isn't any portfolio alternative ever that could be suggested to be compliant except for the one that SPS proposes.
In terms of compliance with the 2045 statute, Madam Hearing Examiner, there are no portfolios that would meet the system needs that could be built from the bids that were received through the competitive procurement process. SPS did not receive sufficient amount of bids in that process to build a portfolio to meet 2045 compliance.
After reviewing the initial bids that came in, did SPS consider rebidding the project?
I don't know whether the bid development team considered rebidding any projects, and I don't believe there would have been an opportunity in the RFP process as a whole for any bidder to rebid projects. Mr. Gable can speak more to that process, but it is my understanding that we don't have a rebid process built into this RFP.
wanted to ask you a little bit more about your testimony on pages 24 and 25 of your direct testimony. And you're answering the, beginning to answer the question posed at lines 1 and 2. Has SPS sought any certifications associated with the projects presented here? And you indicate beginning on line 3, yes. And then you continue your answer at line 12 that says SPS also sought certification from the New Mexico Economic Development Department for actions associated with its 2023 IRP and 2024 RFP under Senate Bill 170, codified in part as 621626E. Why'd you do that, Ms. Lees?
Under Senate Bill 170, if projects are certified, it's my understanding if projects are certified by the Department of Economic Development as necessary for economic development, then the company can enjoy certain changes to CCN requirements, mainly the procedural schedule required. And so SPS felt that it was important to seek certification in order to receive a 6-month procedural schedule under that statute, and so that the commission could look at that certification as part of this proceeding in order to understand the economic development benefits as well.
How does that work? I'm not familiar with it. I mean, do you file it like you file here and get a case number, or?
No, and I think we were the first, maybe the second utility to make such a filing. So we submitted basically an application to the Department of Economic Development. They posted it on their website and solicited comments and positions on it. And then within 60 days, they are supposed to issue a certification or not. I believe it goes to a board in that department. I'm just forgetting what the board name is.
Did you have to present like testimony? Was there a hearing?
No, ma'am. I believe that statute just requires that the department allow for public comment on the application, which the department did receive. And we were not asked to come in to testify or participate in a hearing as part of that process.
Did you get to file any comments yourself?
We did not file the comments ourselves because I think we filed the application with all the evidence that we believed was necessary to certify the projects.
Okay, so you didn't get like a chance if some of the comments were not supportive, did you get a chance for a rebuttal?
No, ma'am.
Okay. Do they have staff that review the application?
I know there's a review process, ma'am, at the Department of Economic Development. I don't know exactly how that works internally.
Did they get you said the board issues a decision?
I believe that they have a board that looks at the application and then issues a decision. Yes, ma'am. But I just can't remember the name of the board, unfortunately.
And is the decision public?
It is, ma'am.
Is it available somewhere?
I believe it should be available on the Department of Economic Development's website, and certainly we can provide it if you'd like it. I will say, and my testimony says this, we got certification of economic development sites in our service territory. We did not get certification of the portfolio. So we did not bring this application forward under certification in that statute.
Yeah, and that's the part I don't understand, and is your testimony at line 2 on page 25. The department did issue a certification related to that application. However, the scope of the certification is unclear. What was unclear about it?
The decision itself stated that it certified that certain economic development sites in our service territory needed infrastructure investment in order for economic development to occur, but it did not have a specific finding that the portfolio that we submitted for certification was necessary for economic development in the service territory. So the decision itself and the way it was structured was just unclear as to what the certification meant. It appeared to be certifying sites, specific sites, rather than the portfolio itself, which we had sought certification of.
That seems pretty clear to me. What sites were certified, but the application wasn't. It says, the next part of your testimony says, while SPS is working with the department to confirm the scope, still working with them on that?
We've not confirmed the scope of that decision at this time, Madam Hearing Examiner.
Is there an appeal process?
If there is, we haven't exercised any rights under it.
Okay.
Madam Hearing Examiner, I'm not clear what that appeals process would look like.
Okay. So how then are you working to confirm the scope with them?
We've requested to meet with them to discuss the decision, and that meeting has not happened yet.
Okay. Then the next part you say, it underscores the economic development benefits associated with self-built projects and the final preferred portfolio more broadly. How so?
The decision, as I understand it, states that there is infrastructure development that's necessary, including development of resources to provide electric capacity for these sites that's necessary to develop them. So I think that underscores kind of one of our messages in this case, that in order to allow for growth on the system, we need the resources proposed in this application.
I believe when I ask you about this certification request, you indicated that one of the reasons that SPS sought this was for the favorable time frame that SPS would be afforded for consideration before the commission, this commission, correct?
Yes, Madam Hearing Examiner, knowing the time pressures we had in meeting reliability requirements at the Southwest Power Pool and the time pressures we had in starting construction for resources to capture PTC benefits for customers, we wanted to exercise every option we had in order to expedite that procedural schedule because of those time pressures. And one of the ways we did that was seeking certification.
And even though you might not have gotten certification of your application, you still got a favorable expedited time consideration of your application here before the commission, correct?
Yes, ma'am. And we are extremely grateful to the parties and to the hearing examiners and to the commissioners for recognizing that there were time pressures on this portfolio and for helping make that happen with the procedural schedule that we got.
considered a bench request. I'd like to see that certification, please. And let me just ask you on, with regard to the time pressures. I mean, in addition to the time that it takes to actually build things, one of the other time pressures indicated in the application has to do with the requirements regarding the potential ITCs and PTCs or the potential tax credits, correct?
That's correct, ma'am.
And my understanding is that basically by the summer, SPS will have to have started the process in order to qualify for those potential credits.
Yes,
If you
ma'am.
know.
And our witness, Miss Fowler, or I believe it's Miss, I'm going to look at my witness list really quickly. I'll look at it in a second, but can speak more to the safe harbor requirements specifically. But we do have certain requirements in order to start getting started on these resources, and in order to safe harbor our ability to capture PTC benefits for our customers.
Do you believe that you'll have any necessary decisions in your Texas proceeding?
It is my sincere hope that we do, and the hearing examiner in that case has acknowledged that there are time pressures, and the parties have acknowledged that as well, that there is a need to make decisions on these resources in order to capture the PTC benefits for customers. So I do believe that the case is progressing in Texas, and that parties acknowledge, and the commission hearing examiners acknowledge, that there needs to be decisions soon.
Did I hear your testimony correctly? I believe in response to Ms. Amer's question. I know it was a cross question, that of the projected self-build I'm trying to think if it was just self-build or if it also included extensions. That only one of the facilities is going to be in New Mexico?
Yes, Madam Hearing Examiner, am I in the right testimony? My testimony was that the Sagamore BESS project and the Maddox extension, which are both part of the self-build portfolio presented in this case, are located in New Mexico.
Okay, so two. Do you know how many, if any, of the potential PPAs relate to facilities in New Mexico?
I believe 2 of the PPAs relate to facilities in New Mexico.
And there's 15 PPAs?
There are 7 PPAs,
7.
Madam Hearing Examiner.
Okay.
And actually, I'm going to amend that. There are 6 PPAs, Madam Hearing Examiner. one of the PPAs did not move forward in the filing that's listed in my my table in my direct testimony.
Okay. And then how many of the extensions relate to facilities in New Mexico?
One extension, Madam Hearing Examiner.
Okay. And the PPAs that are part of the you can tell me its name. The final preferred
Final preferred portfolio.
okay. Uh, those were filed for separately with the commission in case number 250085.
That's correct, Madam Hearing Examiner. We didn't want to further create timing problems for the self-build portfolio by delaying the filing of this case to wait for the commercial negotiation that was going on with the PPAs.
And so that case is pending.
That's correct, Madam Hearing Examiner.
And I just lost it. This is recovery. Is recovery for the 15-year terms of these PPAs. Here it is. It's being considered in your pending rate case, correct?
Yes, Madam Hearing Examiner, we have requests in that rate case as it pertains to the PPAs that will come in service during the future test year.
Okay, all right. Now, because it says of the 6 PPAs, approximately 99.3 million on a total company basis in 2028, the first full year in which all the facilities are expected to be in service. And of that 99.3, SPS has proposed to allocate, I guess, 54.1 million to the New Mexico retail jurisdiction, correct?
I'm not, I think you're looking at my testimony from the rate case, Madam Hearing Examiner. So subject to check, that sounds correct.
Okay, I'm actually looking at your application.
In the rate case? Okay, so
No,
say,
in 85, in the PPA case.
okay, obviously
2500085,
yeah.
page 10, and I'm looking at item 29 on page 10.
I don't have that document in front of me.
Okay.
And it will take me a minute to get it in front of me if you'd like me to, but subject to check, that sounds like what our application says.
Okay, so in the pending rate case, SPS is proposing to capture monies from the PPAs, and then if I recall your testimony, that one of the BESS?
Battery energy storage.
Is that, well, I'll just make it cleaner. Are there any other parts of the requests in this case that are potentially going to also be requested to be recovered in your pending rate case?
And apologies, Madam Hearing Examiner, I've been so focused on this case. I believe our Plant X battery energy storage project has a commercial operation date within the future test year in 2027. So a recovery of a portion of that unit is contemplated in the rate case.
Okay. Thank you, Ms. Lees.
Subject to check, I've been very focused on the application in my testimony in this case, and I need to dust off the cobwebs on the other case.
Did you say Plant X?
Yes, sir. Plant, PLANT, and then separate X.
Thank you very much. Go ahead, Judge.
Thank you. That's all that I can recall I have right now, Ms. Lees. Appreciate your time. How are we doing, Mr. Lee? We want to take a break now, or we want to wait for a few minutes?
We can finish up with Ms. Lees if you'd like, Judge.
Okay.
Madam Hearing Examiner.
Yes, ma'am.
May I have a quick break in order to use the restroom, please?
Sure.
Thank you.
Sure. We'll go ahead and take our 10 minutes and come back, and Mr. Larson, you can have any redirect that you'd like at that point in time. Let's see what time I have. I have 2:35, so we'll come back at 2:45. Just remember, please, that the YouTube stays on.
Thank you.
Time.
All right, Mr. Lee, if we are
I'm
good.
ready. I'm ready, Judge.
All right, we're back from our afternoon recess. Mr. Larson, any redirect for your witness?
Yeah, thank you, Madam Hearing Examiner. Just a few questions. Good afternoon, Ms. Lees.
Good afternoon, Mr. Larson.
Just a few questions based on the examination over the last couple of days. So going back to yesterday with respect to the examination by NMLCG counsel, Mr. Stoffel, you all had an exchange about the Hale and Sagamore projects and performance parameters around those projects. You recall that?
I do.
And are the Hale and Sagamore wind projects, are they surplus projects like the renewable projects here?
No, they are not.
And could the fact that they're surplus projects affect operations and production from the projects?
Yes.
And is that particularly acute with respect to the Sandy Loam renewable project?
Yes, it is.
And I believe you also had a discussion about the market, staying with Sandy Loam for a moment. I think you also had a discussion about the market dispatch of that particular project. You recall that?
Yes.
And I believe you said that Mr. Lytle could talk in more detail about that. Is there more information you'd like to provide as to who could discuss?
Yes, SPS witness Keith Parks can also discuss the market dispatch of Sandy Loam.
And staying with the questions that Mr. Stoffel asked you, you all talked about the timing of performance parameters within the integrated resource planning process. You recall that?
I do.
And why is it important, in your view, to have the performance parameters identified early in the process?
In my opinion, it's important to have those identified early so that we can include those parameters as requirements for bids being bid into the RFP. And so that we know we need to model those performance parameters as well in the bid selection process.
And that's for company-owned projects, knowing what the performance parameters might be as part of the bid.
It's important for projects that the company bids in, but it's also important for projects that independent power producers bid into the RFP as well. They have to bid in projects that conform with our model PPA, and understanding what those metrics are is important in order for them to bid in projects.
So, and independent power producers bid to the model contract.
Correct.
Is that right? And then one more item from Mr. Stoffel's examination. You all had a discussion about allowance for funds used during construction, or AFUDC. Do you recall that?
I do.
And you had a discussion about, projected commercial operation dates. If a project were to go past that commercial operation date, AFUDC increasing on the project. You recall that?
I do.
Can you discuss how Rule 580 would apply in that particular instance where a project, took longer to come in service than perhaps was initially projected, and as a result, AFUDC increased?
Yeah. Yes. If that increased AFUDC caused a cost overrun over the certificated costs, then under Rule 580, the commission would examine that cost overrun for prudency before the company would be allowed to recover those costs.
So changing gears now to New Mexico Department of Justice counsel, Mr. Harris. You had a discussion with him yesterday about the fact that there was a 2-year process and then there was a request for expedited treatment with respect to this particular application. You recall that?
I do.
When did SPS provide its bid evaluation report to the independent monitor?
The end of July 2025.
And was there additional process with the independent monitor after that submission?
Yes, sir. The independent monitor issued its final report on the 120-day report 28 days later. So in August.
So bid evaluation report in July, and then the independent monitor final report end of August. Is that right?
That's correct.
And when did SPS file the case?
On
The
September,
application?
excuse me, SPS filed its application on September 25th, 2025.
So SPS didn't wait 2 years to file its application.
No, sir.
You had a discussion with Ms. Amer on behalf of staff of the commission earlier today about the competitive solicitation and the bids that were received. Do you recall that?
I do.
And were bidders permitted to bid in long duration energy storage, nuclear facilities? Were there any restrictions on what bidders could bid in?
There were no restrictions. Bidders were permitted to bid in any technology.
Did any independent power producers bid in zero carbon dispatchable technologies that you're aware of?
Other than short duration battery energy storage, no.
And by short duration, you mean 4-hour storage?
Correct.
Thank you. And then there was also some discussion about alternative portfolios and alternatives earlier in the hearing today. Do you recall that?
I do.
And can you just describe kind of at a high level from policy perspective, the process that SPS went through in terms of reaching the final preferred portfolio that was presented as part of its application?
Yes, sir, on a high level, during the bid selection process, Mr. Gable modeled many different alternative portfolios. I think those are presented in JLG2. But as we evaluated the multi-jurisdictional baseline portfolio with the RPS projects added onto those, we compared it against an RPS 30 compliant portfolio. I think I testified earlier today that comparison showed that an RPS 30 compliant portfolio included more projects, was larger, was less cost effective and more expensive for customers, and would have resulted in significant curtailments. So we did that analysis, and Mr. Gable did other alternative analyses. And as we realized that we didn't have a resource portfolio that would meet the 2045 requirements in the statute, decided that we needed to do analyses to provide the commission with the information it needs in order to exercise its responsibilities under the statute. So once we realized that there was no possibility for a portfolio that met system needs that would be compliant with 2045 requirement under the Renewable Energy Act, we performed analyses that demonstrated our reliability concerns and our concerns with the undue impact to customer bills, and provided those in this case.
So on the portfolio that was modeled with RPS 30 as part of the base assumptions, not as a bolt-on. One brief question on that. Do you know if the Gaines and Tolk CTGs were selected in that particular portfolio?
I don't recollect, Mr. Larson. You'll have to ask Mr. Gable.
Okay.
I believe they were.
You can ask Mr. Gable. Thank you.
Yeah.
And then just closing out, there's been discussion about the 2045 exception that SPS has requested here. And you just alluded to a little bit of this, but can you just kind of describe the thought process and analysis that SPS went through before deciding to bring that request to the commission?
Yes. SPS, like I just testified to, analyzed different portfolios, and those are discussed in JLG2. But as it realized that it didn't have a portfolio among the options of bids available to it that would be compliant to 2045 requirement in the Renewable Energy Act, SPS understood that it needed to do further analysis to understand what the impacts to system reliability would be, and to what impacts customer bills would be if it did not move forward with the gains and the TOLC resources, in order to provide the commission with the information it needs to grant exceptions.
Everything just froze for me.
Oh,
To grant exceptions.
sorry, Mr. Larson, are you still on?
We can see you.
I'm back. Sorry. We had an unstable internet connection is what the computer is saying. My apologies.
We performed those analyses in order to provide the commission the information and evidence it needs in order to exercise its responsibilities under 62-16-4B in administering the requirements in the statute. Now, the commission, my opinion, that those provisions of the statute provide the commission flexibility in administering the requirements in the statute, in that there are certain things that the commission is charged with preventing from happening. In other words, the legislature has told the commission, you don't have to approve a compliant portfolio at any cost. There's things that the commission should not allow to happen, and SPS performed analyses to demonstrate that in not allowing gains and TOLC to go forward, and instead requiring SPS to replace the need that those resources build with fully compliant resources, would have a material impact on system reliability and an undue impact to customer bills.
Yeah, and then just a couple more questions. So given that, how does SPS view its obligations under the Energy Transition Act?
SPS needs to continue to work to meet the requirements under the Act. It's our responsibility to continue to try and make progress towards those requirements. And it's my testimony that we won't just throw up our hands and say we give up, that we'll continue to work towards those goals stated in the statute.
Thank you,
And
Ms.
no,
please
in
finish.
fact, we've already demonstrated that, in my opinion, Mr. Larson, through the RFI that we issued following the 2023 IRP. And as I stated before, we think WRA witness Ms. Weller's recommendation that we develop a study or an RFP to solicit more zero carbon resources, especially those located possibly in the New Mexico service territory, is a good one, and that we should discuss what such a study or RFP would look like in the current IRP in order to issue it.
And does the 2026 IRP process that SPS is commencing now provide an opportunity to start to look at those types of solutions like what Ms. Weller's proposing?
Absolutely.
Nothing further, Madam Hearing Examiner. Thank you.
Thank you, Mr. Larson. Anyone have any recross based upon the commissioners, hearing examiner, Schaefer, or my questions, or the redirect by Mr. Larson? Looks like I've got two hands. Mr. Harris?
Yes, I have a few questions on both the impact to customers asked by Commissioner Schaefer and the 2-year process that Mr. Larson discussed.
Go ahead, sir.
When you were discussing the possibility of planning for 2 jurisdictions, Ms. Lee, you mentioned the impact to customer bills. Do you remember that?
I do.
So can you give your opinion on what would be worse for customer bills, a 2 jurisdiction planning approach, or what we have now with a 47% residential rate increase?
I think the evidence in this case shows that needing to pivot towards planning a split system would have a much greater impact on customer bills than the bill impacts presented in this case.
Could you be a little more specific with which evidence you're discussing?
Yes, I'll point you to the evidence in my that's referred to in my direct testimony. Give me just a moment. So starting on page 76 of my direct testimony. Sorry. And going through page 80, I, at a high level, introduce the analyses that Mr. Gable and Mr. Trowbridge present in looking at what an alternative portfolio to moving forward with Gaines and Tolk, and instead planning a system in which we would have to replace those resources and with New Mexico, with resources that comply with the 2045 requirement. And my testimony provides that look and refers to Mr. Trowbridge and Mr. Gable's testimony for those analyses. My rebuttal testimony also provides some of that information, and again refers to Mr. Gable and Mr. Trowbridge for that analysis, and I can point you to where that is in my rebuttal testimony.
That's okay. I think I've got a good idea.
Okay.
Let's move on to your response to Mr. Larson about the process and the timing of the application along with the other process. Yesterday you said parties could have made their positions known as early as the IRP process. Do you remember that?
I don't remember. I think I know what you're talking about, but I'm not entirely certain of what exactly you're referring to. But generally in this case, I've testified that some of the parties' positions on how we should have different proposals that the parties bring forward in this case should have been discussed in that IRP process, yes.
Can you quantify the extent to which the IRP plan differs from the application we're considering today?
Well, the IRP provides multiple different modeling scenarios under different load forecasts and different technologies based on generics. So the IRP provided analyses based on generic resources and different load forecasting scenarios, and the RFP provides a resource portfolio modeled after projects that are available and bid into the RFP.
So as a practical matter, any position offered by a party in after the IRP process wouldn't have had much applicability in light of the results
Well,
of the RFP. I'm sorry, earlier I mentioned RFP. I should have said IRP. Sorry for the confusion.
I'm not sure I agree with that. I think a recent example we discussed is in terms of PIMS, it's important to know and understand what those performance metrics are when issuing an RFP, and if that was discussed in the IRP and it could have been considered. And Mr. Harris, I'm sorry, page 45 of my rebuttal testimony, going back to a previous question of yours, provides the projected bill impact and says that it's 40% higher than if gains and Tolk CTGs move forward with the CCNs issued by the commission.
I'm sorry, ma'am. 40% higher, and please slow down.
Then if the gains and Tolk CTGs move forward with the CCNs issued by the commission. And that is for 2031. And then my testimony summarizes the results in those analyses for 2045 as well, and states that we would require nearly 6.5 gigawatts of additional non-emitting resources required to serve New Mexico customers. And that would result in a nominal cost increase of 9.5 billion, or a 5.5 billion increase on the net present value basis from 2031 to 2045. So I just wanted to make sure you had the citations to the information you were requesting.
Well, I know compound questions aren't allowed. I don't know what the rules say about compound answers.
Trying to be helpful,
So
Mr. Harris.
Are you saying that beyond the 47% bill increase projected in this application, separate jurisdictional planning would result in 40% increases above that 40%?
Let me go back to my testimony.
Page 45 of your
Thank
rebuttal.
you. Yes, by 2031, my testimony says the projected bill impact in this time frame is 40% higher.
Okay, thank you. I have no further questions.
Thank you, Mr. Harris. Ms. Drake?
Thank you, ma'am. Let me lower my hand so I don't lose track of it. And I understand I have 13 minutes left for Ms. Lees. Is that correct?
Well, I didn't really build any time in for recross.
Okay.
So you're just
All right.
limited to the questions that
Correct.
commissioners, hearing examiners, or the redirect.
That's what I'm going to limit myself to. Thank you. Good afternoon, Ms. Lees.
Good afternoon, Ms. Drake.
So over the past 24, 25 hours of cross-exam, you've responded to questions multiple times that SPS looked at alternatives within the RFP, and that SPS ended up not having available bids within the RFP to be both for 2045 compliant with the New Mexico RPS and to meet reliability needs. Is that right?
My testimony has been that we looked at alternatives, and among the bids available to us to model, we could not build a portfolio that was fully 2045 compliant without having significant reliability concerns. But I mean, the bottom line is we didn't have enough bids in order to build a portfolio that would be 2045 compliant.
Right. Okay. Thank you. Is it your understanding that the IRP rule or some other rule constrains SPS to not consider alternatives outside the bids you received?
It's my understanding that under the IRP rule, we're required to issue a competitive procurement for resources. And if those resources are going to contribute towards compliance with the Renewable Energy Act, under the statute, they must be competitively procured.
Under which statute?
The Renewable Energy Act.
Okay, but I'm asking you about the IRP rule.
Yes, and I said my understanding under the IRP rule, if we're going to procure resources to meet the statement of need as articulated in the IRP, we need to follow the procedures under the RFP provisions of that rule.
Which you did, right? You followed those procedures. At least that's what you testified that you did, correct?
SPS followed those procedures, yes.
Yeah, and you ended up in the situation that you found yourself, that you just didn't have the bids available to both meet your stated reliability need and to be 2045 compliant with the RPS, correct?
That's correct. In this RFP, we were not able to build a portfolio that did those things, both those things.
So I'm sorry, in that situation, when you found yourself in that spot, are you saying that the IRP rule constrained SPS to not consider alternatives outside the bids you received?
I don't know
sorry,
if I'm sorry, Ms. Drake, what were you going to say?
I was just going to ask if there was somebody else speaking.
Hearings examiner Hurst, you're not muted, I think, is the background noise.
Drake.
Ms. Drake.
Or Ms. Lees.
Okay, sorry. For hearing examiner Schaefer, did you want to say something?
No, go ahead.
I didn't mean to
saying,
interrupt.
Ahead, yeah.
Oh, okay.
No, go ahead. We're all.
Okay. Ms. Drake, am I understanding that remembering the question is whether there's any opportunity to examine alternatives in the IRP rule?
Actually, let me restate it so we're both clear, okay?
Okay, thank you.
In the situation that you found yourself, was it your understanding that the IRP rule constrained SPS to not consider alternatives outside the bids that you received?
My understanding is that the rule requires us to conduct an RFP that's competitive, fair, and transparent. We do that under the supervision of an independent monitor, and that looking at alternatives outside of the competitive procurement to procure resources would not be in line with the rule. And if those resources, in addition, were going to be compliant with the Renewable Energy Act standards, that statute requires that we competitively procure those resources. Now, I'll also say that we've already issued another RFP, so we're still seeking resources.
That was my next question. Thank you. So you did issue a follow-up RFP for renewable energy resources to help SPS comply with the Renewable Energy Act, correct?
That's correct.
Yeah. And SPS did that because you did not have the bids to comply, so you needed to issue a follow-up RFP to obtain the resources to help SPS meet its RPS requirements, correct?
Yes, the multi-jurisdictional baseline portfolio and the Sandy Loam project help us make progress towards the 2030 requirement, but it doesn't get us all the way there. So SPS issued another RFP in order to solicit, in part, for resources to help us meet that requirement.
Understood. Thanks. So did SPS consider alternatives regarding capacity resources outside the RFP bids to replace the thermal resources that do not comply with New Mexico law, while you're still proceeding with a CCN proceeding for the other resources proposed in this case? Did you consider that at all?
Consider alternatives? Ms. Drake, sorry,
Yes.
I'm confused about what you're.
Let me restate it. So you issued a follow-up RFP for renewable energy resources to comply with the RPS. Did you consider a follow-up RFP or any other alternatives regarding pursuing or finding capacity resources outside or in addition to the RFP bids that you already received, but to replace the thermal resources that do not comply with New Mexico law?
I don't know of any other alternatives available to replace those units, as we didn't receive any other alternatives in the RFP process, Ms. Drake.
Right, but she's asking you whether or not you considered when you didn't have enough renewables, you issued another bid. Okay. So if you didn't have any alternatives for the thermals, because you didn't get enough bids, did you consider doing another RFP for them?
No, ma'am, and I was going to continue that we did not consider issuing another RFP to replace the Tolk and Gaines resources because those resources were selected as the most reliable, cost-effective portfolio. And I would have concerns about the competitiveness of the RFP if we disregarded the bids received in that. And we need to plan the system on as a whole. And the most cost-effective, reliable portfolio at the time included Gaines and Tolk. And we have very near-term needs for PRM compliance that we needed to take into consideration. And Tolk is set to retire in the near term as well. So we considered this RFP as the one that was solutioning those needs, and these were the bids that were received.
Do you need renewables for your whole system requirements?
Renewables are definitely a technology that is necessary to meet our system requirements, and that's why they are included in this final preferred portfolio.
But are you required in your Texas jurisdiction to have a certain percentage of renewables or a certain type of renewable energy similar to the requirements in New Mexico?
No, ma'am, not similar to the requirements in New Mexico.
Are you required to have them at all?
There is a sunsetting requirement, so I think it's at the very end of the statute. It either sunsetted at the end of last year or this year. So effectively, the answer is no. There was a small renewable energy requirement, RPS requirement, that is sunsetted in Texas.
So when you have this additional renewable bid that you have issued, that's totally for the New Mexico jurisdiction of SPS, correct?
So the RFP that we have issued is still seeking to solution accredited capacity needs that we have in 2030. And we've also included as one of the options in that bid the need to solicit additional resources to help meet the RPS standards in 2030.
It seems like I recall that there was a time years ago when SPS had a huge number of surplus RECs. Is that correct?
I think that's accurate, Miss Hurst. For a while, we had enough recs to bank every year.
Is that not the case anymore?
No, ma'am, that is not the case. Looking forward through the resource acquisition period.
Thank you. Go ahead, Ms. Drake. Anything further?
Yes, please, unless you have more. I'll go forward. Okay. So did SPS consider obtaining short-term capacity purchases while you seek additional capacity resources that comply with the NMRPS?
We are considering short-term capacity purchases. It's one of the options that we are evaluating and seeking whether those purchases are available in order to meet our PRM requirements.
But it doesn't sound like you're proposing that as an alternative to the Gaines and Tolk plants at this time, correct?
No, we're not, and I'm not aware that there are that there's available capacity purchases that would be able to replace those two projects. I'm not aware of that.
Okay. Did SPS consider paying the SPP deficiency payment in the interim while seeking additional resources that comply with New Mexico law?
No, ma'am. SPS is planning its system to meet the reliability requirements that it must meet. That it's required to meet.
Understood, but I recall in your rebuttal testimony that you make the statements that those payments could be on the order. I mean, we don't have a specific number, I understand, but I believe you testify they could be on the order of hundreds of millions of dollars. Is that right? Is that your recollection of your testimony?
Yes, ma'am. The deficiency payments could be hundreds of millions of dollars. I think I have an exact number in my testimony, but
yeah, I understand. And neither you nor I are mathematically inclined, correct?
I can only speak for myself, Miss Drake.
Well, I can speak for myself, but at least I think we can agree between the two of us and for the record here that hundreds of millions of dollars is at least an order of magnitude less than the 9 to 10 billion dollars that your proposed resources could cost New Mexico ratepayers. Is that correct?
Hundreds of $1 million is a lower number than the $9.4 billion presented in this case. I will note, though, that paying the deficiency payment does not obviate our need to acquire resources to meet our reliability needs. So that deficiency payment would be on top of whatever capital investment we need to make as a company in order to meet PRM requirements in the future.
I understand, and I frame that question specifically in the interim, that the alternative I posed was paying the SPP deficiency in the interim while you sought additional resources. I'm not suggesting that you land on that as a permanent solution. Just to
and I'm not sure that really is an option for us in terms of our own system reliability. Mr. Gable can talk about whether deciding to forego building Tolk and Gaines and instead paying deficiency payments would be an operationally sound decision to make.
Okay. We'll leave that to the engineer. Is that right?
Mm-hmm. Yes.
So just to finish my line of options here, did SPS consider any other option other than just going with whatever bids it had left from the RFP?
believe JLG2 provides all the alternative portfolios that Mr. Gable modeled in this portfolio, but outside of the RFP, instead of bringing forward games and Tolk, I'm not aware of any other options that we have other than foregoing building those resources now, and in my view, creating some problems for our system going forward.
Okay, thank you. Did you compare and add up and then compare the costs of any or all of these options that we've just gone through to compare those to the costs of your self-build portfolio?
I'm not aware that we have, and I'm not aware that that all the options that we discussed have a monetary value on them that we could add up and compare.
Okay. Same question, I guess. Did you add up and compare the costs of any or all of these options to the cost of your final preferred portfolio?
I believe that the alternative to building Gaines and Tolk has been discussed by Mr. Gable and what that modeling looks like. And Mr. Trowbridge has provided the analysis of what the impact and the cost of that alternative would be.
But specifically with respect to the options we just talked about.
I'm really sorry, Ms. Drake. I am not clear on specifically all the options that we've talked about at this time. We talked about, you could issue other RFPs, you could do all of this stuff. So my answer is no, because I'm unclear as to the specifics, I guess, of all of the options you're discussing.
So we talked about obtaining short-term capacity. We talked about paying a deficiency payment in the interim. We talked at least about those two, and going out on an RFP for additional capacity resources that could also comply with New Mexico law. Did you add up and project the costs of any or all of those and compare those to the costs of your final preferred portfolio?
If we did, certainly Mr. Gable can testify to that. I'm not aware that we were able to understand, for example, what the short-term capacity purchase cost would be for these resources, because I'm not aware that there's sufficient short-term capacity purchases we could have made in lieu of bringing these resources on.
So we should ask Mr. Gable?
Yes.
Okay, thank you. That's all I have. Madam Hearing Examiner?
Thank you, Ms. Drake. Okay, any further recross? Doesn't look like there is. Ms. Lee, thank you very much. You are excused.
Thank you.
Thank you, Ms. Lees.
Mr. Larson, Ms. Hardy, you have another witness.
We do, Madam Hearing Examiner. We would call Mr. Gable.
Is Mr. Gable coming in the same space as Ms. Lees?
He is. So we may need a moment here as they swap out.
Okay, well, let's just look at where we are. But we had some momentum. I think it slowed down today, so let's try to pick it back up today. It looks like parties. It looks like Mr. Gable wins the second most projected cross. I have him at approximately 270 minutes. Perhaps people can be quicker than that, and I know a few people used up some of their time in the previous cross, And we are going to begin our cross-examination of Mr. Gable. With the large customer group who I believe reserved 35 minutes. Mr. Gable, can I see you now?
Yes, ma'am. Can you hear me?
There you are. Welcome.
Thank you, Madam Hearing Examiner.
Mr. Lee, would you please swear Mr. Gable to our proceeding?
Mr. Gable, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter now pending should be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, sir.
Thank you, Mr. Lee. Mr. Larson, are you presenting Mr. Gable?
Yes, ma'am, I am.
Go ahead, please.
Thank you. Good afternoon, Mr. Gable.
Good afternoon, Mr. Larson.
Can you please state your full name?
My name is Justin Lee Gable.
And by whom are you employed and in what capacity?
I'm employed by Xcel Energy as the Director of Resource Planning and Bidding.
And do you have before you what's been marked as Exhibit SPS 6?
Yes, sir.
And can you identify that document?
This is the direct testimony of Justin L. Gable on behalf of Southwestern Public Service Company.
And does that document also have attachments?
Yes, sir.
And were these documents prepared by you or under your direction?
Yes, sir.
And if I asked you those same questions today, would your answers be the same?
Yes, sir.
And are all those answers true and correct to the best of your knowledge?
Yes, sir.
Madam Hearing Examiner, we would move the admission of Exhibit SPS 6, the direct testimony of Justin Gable.
Any objection to what's been identified as SP? Mr. Gable's confirmed by him here today. Hearing no objection, SPS 6 is admitted. Mr. Larson?
Thank you. Mr. Gable, do you have before you what has been marked as Exhibit SPS 7?
Yes, sir.
Can you identify that document?
This is the rebuttal testimony of Justin L. Gable on behalf of Southwestern Public Service Company.
And does that document have attachments?
It does.
And were all of these documents prepared by you or under your direction?
Yes, sir.
If I asked you the same questions in the document, would your answers be the same?
Yes, sir.
And are all of those answers true and correct to the best of your knowledge?
Yes, sir.
Madam Hearing Examiner, we would move the admission of Exhibit SPS 7, which is the rebuttal testimony of Justin Gable.
Any objection to what's been identified as SPS Exhibit 7? Mr. Gable's rebuttal testimony as affirmed by him here today. Hearing no objection, SPS Exhibit 7 is admitted. Mr. Larson?
Thank you, Madam Hearing Examiner. No further questions for Mr. Gable on direct examination, and he is available for cross-examination.
I think we probably want to go ahead and admit SPS Exhibit 8.
And I do not have Exhibit SPS 8 in front of me, but I certainly can work on that.
Okay, I don't believe that we are going to specifically mention SPS Exhibit 8, but it's my understanding that SPS Exhibit 8 is Mr. Gable's confidential testimony.
My apologies, you're correct. Mr. Gable, do you have before you what's been marked as Exhibit SPS 8?
Yes, sir.
Can you please identify that document?
It's also labeled the rebuttal testimony of Justin L. Gable on behalf of Southwestern Public Service Company.
And does that document have attachments?
I do not. Oh, 1 second. Yes, it does.
And
It has it says this exhibit is accessible electronically on iManage, but it does say that there's an attachment GLG3.
Thank you. And was this prepared by you or under your direction?
Yes.
If I asked you the same questions in exhibit SPS 8 that are in there, would your answers be the same?
Yes, sir.
And are those answers true and correct to the best of your knowledge?
Yes, sir.
With that, we would move the admission of exhibit SPS 8, which is the confidential rebuttal testimony of Mr. Gable.
Any objection to what's been identified as SPS Exhibit 8, the confidential version of Mr. Gable's rebuttal testimony as identified by him here today? Hearing no objection, SPS Exhibit 8 is admitted. Should anyone have any questions for Mr. Gable with regard to Exhibit 8, please identify. If you're not going to be able to ask the question in a generic fashion, please identify that you're going into a confidential realm, and so we can deal with it accordingly, procedurally. Mr. Larson, anything further?
Outside of a thank you for reminding me about exhibit SPS 8, nothing further, and he's available for cross-examination.
Very well. Thank you, sir. Mr. Stoffel?
Yes, good afternoon.
Good afternoon. You have questions for Mr. Gable?
We do, and in the vein of good news, we reserved 35 minutes. I used 10 for Miss Lee's. I'm hoping to do this in about 15. See if we can make it.
Okay, great. Go ahead, sir.
Good afternoon, Mr. Gable.
Good afternoon, Mr. Stoffel.
For the record, I'm Nick Stoffel, one of the attorneys representing the New Mexico Large Customer Group in this proceeding. I'd like to start our discussion today regarding the 2024 RFP and the modeling process SPS used to evaluate bids. You are the correct witness for that discussion, right?
Correct.
All right. The purpose of the 2024 RFP was to identify projects to reliably and cost-effectively serve customers in New Mexico and Texas through 2030 and beyond, correct?
It was used to identify resources between the capacity need period between 2027 and 2030.
I'm sorry, between the capacity, and you're gonna have to slow down.
Apologies. The RFP was designed to solution resources between 2027 and 2030 as the capacity need period.
With the understanding that those resources would serve customers through 2030 and beyond, correct?
Yes, sir.
And SPS used the Encompass model to determine the most cost-effective portfolio based on various assumptions, right?
Yes, sir. The Encompass model was used as a component of our evaluation.
And those assumptions in Encompass included the extent to which certain projects qualified for tax credits, right?
Yes, sir.
The assumptions also included the output from renewable generation facilities, right?
Yes, sir.
And production from renewable facilities impacted the amount of production tax credits that were generated, right?
Yes, sir.
And it also impacted the amount of zero fuel cost energy, correct?
Yes, sir.
SPS's assumptions regarding the performance of renewables also reflected any limitations due to the use of surplus interconnection, right?
That is correct.
60% of a bid evaluation score was based on price using the levelized cost of energy or levelized cost of capacity, correct?
That is correct.
And by price, that is really the net present value of the forecasted costs and benefits of the different resource portfolios, right?
That is correct. Just For just a clarification here is just that the pricing component that you're talking about was a part of a staged approach to get to the Encompass modeling.
And the Encompass modeling then produces different net present values of alternative portfolios?
Yes, sir.
And in a net present value analysis, a discount rate is applied. Is that right?
Yes, sir.
And the discount rate reduces costs and benefits that are further out in the forecast period more than costs and benefits in the earlier part of a forecast period, right?
That is my general assumption, yes.
And production tax credits from renewable resources are produced in the first 10 years of a project's life. Is that correct?
For the production tax credit, that's correct.
And production tax credits reduce the overall cost of new renewable generation resources. Is that accurate?
That is accurate.
So the multi-jurisdictional baseline established a least cost system-wide portfolio to address system-wide energy and capacity requirements, but does not incorporate state-specific requirements like New Mexico's renewable portfolio standard, right?
Yes, the MJB was designed to meet the system-wide need at the least cost. I will say though that if energy was or RECs that were generated from resources in the MJB can contribute to RPS compliance though.
And then because the MJB fell short of complying with New Mexico's RPS in 2030, SPS solved for additional New Mexico RPS compliance resources with additional renewable projects, right?
That is an accurate statement for the final preferred portfolio. It's not the only way with which we modeled.
So resources added for RPS compliance provide incremental reliability and resiliency benefits, including additional capacity, correct?
They have the potential. There was not the purpose of their selection though.
But you admit that resources added for RPS compliance provide incremental reliability and resiliency benefits, including additional capacity, correct?
They have the potential to.
You look at your direct testimony, page 76 of the PDF, 70 of the testimony. Beginning on line 12 there.
Well,
I guess let's begin on line 10. There, your testimony, are you there?
Yes, sir.
Okay. So there, between lines 10 through 16, you do not describe potential. You say they do provide incremental reliability and resiliency benefits, including additional capacity, correct?
Mr. Stoffel, I'm sorry, but there was a break in the connection.
Okay. So looking at your testimony, direct testimony, page 70, lines 10 through 16, specifically on line 14, there you're describing the RPS resources, correct?
Yes, sir.
And on line 14, you say these benefits include additional capacity, right?
Yes, sir.
It doesn't say the potential for additional capacity, does it?
You are correct.
Thank you. Self-builds and the pending long-term power purchase agreements do not satisfy the capacity needs that RPS has or the renewable portfolio standard requirements in 2030. Is that right?
Could you state your question one more time, please?
The proposed self-build projects here and the long-term power purchase agreements and the self-build project, all the components of the final preferred portfolio that are being advanced that weren't withdrawn, they do not satisfy SPS's capacity needs or the need for additional renewables to meet the renewable portfolio standard in 2030, correct?
They make substantial progress to it, but they are not sufficient in themselves.
And then SPS has another RFP that you're currently reviewing the bids that you received in the last couple of weeks, correct?
Yes, sir.
And so future resource additions that will be added to SPS's system will be based on current and expected capacity from existing company-owned resources and power purchase agreements and expected resources based on what's approved in this CCN proceeding, correct?
Yes, the 25 RFP is designed to incrementally solve the additional needs past what this resource portfolio is looking to solution.
And so those you describe them as incremental. So that's incremental to what you already have on the system or what you expect to have on the system, right?
Yes, sir.
And so that's incremental to any resources that might be directly assigned to New Mexico, like the Cunningham battery, right?
Yes, sir.
And that's incremental to any capacity that might be directly assigned to New Mexico, like the capacity from the Sandy Loam project, correct?
Yes, sir.
So you have some discussion in your rebuttal testimony about the potential splitting of the system between Texas and New Mexico, right?
Yes, sir.
From the perspective of complying with the Southwest Power Pool's resource adequacy requirements, the focus is on SPS's capacity as an overall system and not on New Mexico as a standalone entity, correct?
That is correct.
And so SPP does not care how SPS's resources are allocated between New Mexico and Texas for recovery through retail rates, correct?
I think, yes, the Southwest Power Pool looks at SPS's resource adequacy on a system-wide basis, which includes Texas and New Mexico combined and does not separate them by state.
And evaluating the adequacy of SPS's resources does not include any consideration of where the costs of those resources are allocated for recovery from retail customers, correct?
That is correct. It does not take into consideration cost allocation.
So the Southwest Power Pool's resource capacity accreditation for renewables and battery energy storage systems depends on the resource's effective load carrying capability, or ELCC, right?
That is correct.
And the capacity, the accredited capacity of renewables and battery electric storage systems ultimately depends on how those resources perform over time, correct?
That is a component of it. There's performance is included in the calculation. There's also things like total penetration of the technology type on the SPP wide system.
You got to my next question. So the value of the capacity value of renewables and battery storage systems can decline if the performance declines over time, right?
Yes, sir.
And then it can also decline as more of that technology type is added to the system.
That technology type, or also the ratio of other technology types.
Thank you, Mr. Gable. I have no further questions. I think that hopefully made up some time, Hearing Examiner Hurst.
Thank you, sir. I believe, Mr. McMillan, that you are next, and I believe that you reserved 70 minutes for Mr. Gable.
That's correct.
Go ahead, sir.
Hi, Mr. Gable. My name is Michael McMillan. I represent OPL in this proceeding. How are you today?
I'm doing well. How about you?
Doing pretty okay. So I want to start in your rebuttal testimony on page 21, and at line 18. Let me know when you're there.
Okay, 1 second. Okay, page 21.
Yes.
And what line was it?
On line 18.
Okay,
Oh,
the line 18 that I'm reading starts with a
okay.
sentence.
Pardon me. It starts on line 17. You say that RFP, you mean the 2024 RFP, solicited bids of all technology types and was open on fair terms to any bidder who wished to submit a CCGT bid. Did I read that right?
That is correct.
Okay, but bids in the 2024 RFP, well, they had to meet the requirements of the RFP to actually be considered, right?
That is correct.
So if, say I'm a prospective bidder and I know I can't possibly meet the requirements of an RFP, it would be a waste of my time to submit one, right?
The requirements to enter a bid into the RFP were identified in the RFP, and all bidders were made aware of those. Yes.
Yeah, but hypothetically, if I'm a potential bidder, if I know I can't meet the requirements of an RFP, it's pretty unlikely I'm going to submit a bid, right?
If my project did not meet the requirements of the RFP, I would not submit it.
And you'd agree that SPS was the only bidder to submit a bid for any type of gas thermal resource in the 2024 RFP, correct?
Yes, Xcel Energy was the only company to provide a thermal bid for the 24 RFP.
And you maybe just corrected me on something. What was it, Excel doing that or SPS itself?
Subject to check, I would say it was Xcel Energy.
Okay, I'll try to keep saying Excel rather than SPS for consistency. Thank you for that clarification. So of the bids that Excel submitted for gas thermal units, there were a total of 9 of those bids, right?
I'd have to go back to look at that information. That sounds correct.
And of those 9 bids, 2 of them were informational bids for CCGT resources, correct?
Yes, we received 2 bids from the company, and those bids were labeled informational bids.
And those informational bids were for combined cycle units, correct?
There were 2 separate projects. Each was for combined cycle technologies. Yes.
Okay, and okay, if you could turn to page 31 of your rebuttal testimony and find line 10 and let me know when you're there.
One second. All right, line 10.
Yes, and let me know when you're there.
Yes, this is in response to the question, are CTGs a reasonable choice?
That's correct on line 9. So
Yes.
on line 10, you start yes. First, it is telling that no other bidder submitted a CCGT bid in response to the 2024 all source RFP. If the need for a CCGT, as opposed to the resources actually selected in the RFP, was so obvious, SPS would have seen a market response to that effect. Did I read that right?
That's correct.
So, Mr. Gable, it's fair to say that in this proceeding, SPS is taking the position that there's an obvious need to build 2 new CT units at Gaines and Toll, correct?
I think that what we are saying here is that the company has made apparent our needs, and that if a bidder thought that a CCGT was the best project for SPS to select, then they would have provided that bid.
Well, so right now, and I realize you're trying to link it to the testimony that I just read, which is reasonable, but we'll get back around to that in just a second. So right now, I'm just asking about this proceeding, this CCN proceeding. Now, in this proceeding, SPS is taking the position that it has a need to build 2 CT units, one at Gaines and one at Tolk. Is that right?
No, I would say that the 23 IRP identified that there was a firm dispatchable need for SPS. I don't think that we've identified the specific technology to meet the firm dispatchable, but if a company thought that it was apparent that that bid should have happened, that they could have provided that bid.
Okay, so I think we're still talking past each other just a little bit here. And so I'm just saying in this CCN proceeding, that we're all here for today. SPS has presented a portfolio of resources that it is saying to the commission it needs. Am I correct that that's what a CCN is about?
Yes, the SPS, we are presenting the final preferred portfolio as the resources SPS needs today. Yes.
And that final preferred portfolio that SPS is presenting contains 2 CT units, one at Gaines and one at Tolk, right?
It's 9 units, 5 at Gaines and 4 at Tolk.
Pardon me, 2 CT facilities rather than units. That was imprecise.
Yes, sir.
Okay, thank you. So, but during the 2024 all source RFP, no bidder other than SPS, or excuse me, other than Excel provided bids for CT facilities. Is that right?
That is correct.
So is it fair to say that there wasn't really a market response for CT facilities in the 2024 RFP either?
I can't presume why other people did not make those bids. I don't know why they didn't bid those in if they didn't provide the bids.
But it's fair to say that out of the total market, potential market for new generation that could have bid into the 2024 RFP, only Excel bid in CTs, correct?
Yes, only Excel Energy bid in CTs. You're correct.
Okay, in your opinion, was it possible for any bidder other than Excel to have submitted a viable gas generation bid that would have satisfied the requirements of the 2024 RFP?
Maybe phrase the question one more time.
Yes, in your opinion, was it possible for any bidder other than SPS to have submitted a viable gas generation bid that would have satisfied the requirements of the 2024 RFP?
I can't imagine other scenarios. Yes.
Okay, can you turn to page 34 of your direct testimony?
Okay, 1 second.
I need to get there myself.
Okay, I think I'm on page, you said 34, right?
34 of your direct, that's correct. And I'm not gonna read it to save a bit of time, but Mr. Gable, between lines 6 and 8 on that page, you explained that SPS's 2024 RFP specified that generation projects that required a new generator interconnection agreement had to have at least reached phase 2 of the SPP definitive interconnection system impact study or DISIS process. Is that right?
For a project requiring a new GIA, which was one option of the RFP, that was correct. You needed a phase 2.
And another option is to use an existing GIA where existing generation was retiring. Is that right?
Yes.
So it's public knowledge where projects are in the DISIS process at any given time, correct?
There's some information that's public. I would say that, I mean, you have a general identification of a size of a project that's in the DISIS. I don't think that you have any identifying information about whose projects those are. So there is limited information, yes, available in the DISIS that's public.
Okay, can you turn to page 31 of your rebuttal testimony for me?
Yes. 1 second. I didn't save that page, so I apologize.
Oh, take your time.
You said, oh, okay, page 31, right?
Page 31, starting, it's that same question that we were just looking at in your rebuttal. We read the part that said first, and now I'm going to go to line 13 and start there with second, and let me know when you're there.
Yes, I see it. Do you want me to read it?
I can read it out and you can confirm for us. You say starting on 13, second, a recent review of the DICES queue cluster group 05, for which SPS resides, at SPP does not show any additional CCGTs in subsequent clusters, indicating that the market for such development in the SPS service territory remains thin. Did I read that right?
Yes, sir.
Okay, so it's fair to say from that one can go and look up whether or not there are CCGTs or CTs in the DICES process and where they are in that process. Is that right?
That is correct for the option for new generation that requires a new GIA. That's correct.
Okay. So at the time that SPS was creating the 2024 RFP, do you know if SPS was aware of what proposed thermal generation projects had completed stage 2 of the DICES project in the relevant geographic area?
Can you state the question one more time? Because I think I have a question about your question. Apologies.
Sure. So at the time SPS was creating the 2024 RFP, do you know if SPS was aware of what proposed thermal generation projects had completed stage 2 of the DICES project in the relevant geographic area?
So what I would say is like SPS, I don't know if that's a precise enough like term. I mean, because I'm part of the bid evaluation team in SPS. My team helped develop the 24 RFP. So can I say that was SPS aware? I'm sure SPS as a company was generally aware, but for me myself, I can't recollect if I knew exactly what was in the DICES at that time or not. It's not something that I recall.
Were you aware when developing the 2024 RFP that the Gain site had completed phase 2 of the DICES process?
I'm sure that information was available to me, but I don't remember that I specifically went to look that information up.
Okay, so let's see, that your response lets me skip a few questions, so bear with me just a moment.
Okay.
Mr. Gable, is it fair to say that SPS as a company is generally aware of the generation resource sites that exist in its service area?
I would say generally, I mean, there's several departments inside of SPS with transmission, distribution, generation. Some have more, that type of information is more relevant to specific folks at a specific time. So, but yes, generally the company does, yes.
Let me be a little bit more precise. Speaking specifically of very large generation sites, let's say a couple 100 megawatts or more, would SPS be aware of the very large generation sites that exist and have in its service area and have generation interconnection agreements?
I mean, in general, yes. Like I said, though, there's not a lot of identifying information. It could very easily be that there could be something in the DICES that's in the Group 5 area, which includes SPS, that may not necessarily be a company project.
Okay, so I've moved on from the DICES to talk more about the alternate path that you were talking about, where existing generation resources with an existing interconnection agreement with the SPP could potentially retire and clear up space. So are you with
Okay.
me that we've switched topics a little bit?
Yes, we're talking about surplus now. Is that what you're referring to?
If that's the correct vocabulary word, it's escaping me, but I believe we're on the same page. We're talking about existing resources with
Okay.
oh, yes, you're right. It just clicked for me. Surplus is the correct word. Thank you for that, Mr. Gable. So yes, speaking
Surplus or replacement, probably. Sorry.
surplus or replacement capacity, is it fair to say that SPS would be aware of the large, more than a couple 100 MW sites with existing generation resources that exist in its service area?
Yes.
Is it fair to say that if a very large generator, even if it's an independent power producer, if a very large generator is going to retire, that's something that SPS would likely know about?
Yes.
Okay, so I want to move on just a little bit. So the IRP process, the conclusion of the IRP process uh, occurred on October 13th of 2023, correct?
That's correct. I think that is the day that the report was filed.
The final report, is that right?
Yes, sir.
Okay. To your knowledge, Mr. Gable, what steps did SPS take to advance a potential CCGT project at the Gaines site between when the IRP concluded in October of 2023 and when the RFP was issued in July of 2024?
As I was on the bid evaluation team, that question might be more aptly handled by Mr. Gertz. I don't, because I don't participate in the development of those projects.
Okay, thank you for that. I'll reserve that for Mr. Gertz. One moment, sorry.
You're fine.
Okay, so in your rebuttal testimony, part of your reasoning for why no viable CCGT bids were submitted is that SPS, or Excel rather, did not believe that a CCGT could meet the requirement for a commercial operation date by May of 2030. Is that right?
Can you point me to the testimony what we're talking about?
I don't have a line number for that one, but is that generally an argument that you make in your rebuttal testimony?
In general, what I would say is that the informational bids indicate that a viable bid for CCs could not be entered into the RFP.
And if I wanted to ask questions about how that determination was made, would Mr. Gertz be a better person to talk to about that as well?
On what bids the company decided to bid into the RFP, yes.
And on the question, and on questions related to why Excel believed that it couldn't meet May 2030 commercial operation date with the CCGT. Is that also Mr. Gertz?
If it's specific to the project development, I would say Mr. Gertz is the appropriate person.
Okay, Mr. Gable, I'm going to move on to a different topic now. And in your rebuttal testimony at page 22 is where we're headed.
1 second. All right, I'm on page 22 of the rebuttal.
Okay, and I'm going to start on line line 3, where you say instead.
Yes, sir. Would you like me to read it?
I can read it out for us and you can confirm. So you say instead, it is evidence that the technology, and by that you're referring to CCGTs, was incapable of meeting SPS's customers' near-term needs because it was not possible to provide a commercial operation date within the CNP. And I'm going to stop briefly there. Did I read that correctly so far? Just to put a pin in that.
That's correct.
And that acronym CNP, that means certified need period.
Capacity need period.
Capacity need period. Thank you. And then I'm going to keep reading from CNP. So within the CNP or provide certainty on what technologies, e.g. carbon sequestration, should be coupled with to meet EPA regulations under Section 111B of the Clean Air Act. Did I read that right?
That's correct.
Mr. Gable, what's your understanding of the regulations under Section 111B of the Clean Air Act that you referred to there?
So I'm not the expert on this, but my general understanding for Section 111B of the Clean Air Act is that a capacity factor of over 40% would require either the conversion to hydrogen fuel or the requirement to add carbon sequestration by 2032.
Okay, and that requirement applies to all gas thermal generation, correct? CTs and CCGTs?
I believe that's correct, but I'm also not the expert on the environmental regulations.
So just once again, with the understanding that you're not an environmental regulation expert, but you did get at this idea. So if a CT would run above, a new CT would run above a 40% capacity factor, those Section 111B regulations would require some kind of hydrogen conversion or carbon sequestration in the near future, right?
According to that regulation, in my understanding, something that a thermal generation unit that operated with 40% would ultimately be required.
Okay,
either convert to hydrogen or to have carbon sequestration.
Sorry for talking over you there.
That's okay. I did the same. Sorry.
And conversely, if a CCGT was projected to run at a capacity factor below 40%, then those regulations would not apply, right?
That's my general understanding of it.
To your knowledge, Mr. Gable, are those EPA regulations under Section 111B still in effect today?
My understanding is that the rule has some that there is, it is in an unknown state right now, ultimately where it will end up. I don't know where the exact state is today, but I do understand that there is potential for it to go away in the future.
And by that, do you mean that the EPA under the current administration is working on repealing those regulations?
Like I said, I'm not the exact expert on this, but my general understanding is that that rule could potentially be changed or amended or removed. I'm not exactly sure what ultimately the fate of that rule will be.
Okay. See, in your rebuttal testimony, and not referring to a specific page here, but generally, you present a few criticisms of OPL witness Mr. Lee's break-even analysis. Is that right?
That's correct.
Okay, so let's go now to a specific page, page 26, and start at the very last line of that, and let me know when you're there.
Yes.
Okay, so you say there, contrary to Mr. Lee's assertion, SPS did not project the weighted average capacity factor of the proposed new CTGs would range from 27.9% to 53.9%. Did I read that right?
That is correct.
Okay, and continuing from there, you say instead, using a weighted average capacity factor, i.e. the capacity factor modeled or based on modeled operation over the life of the asset. In preparing this rebuttal testimony, SPS projects the weighted average capacity factor for the proposed CTGs would range from 18.8% to 27.6%. Did I read that right?
Yes, sir.
Okay, your rebuttal doesn't explain how you arrived at that revised weighted average capacity factor range, does it?
It uses the information that was provided to us by Mr. Lee in discovery. That's the difference between his calculations and mine is that Mr. Lee had used the generic resources capacity factors from a lock tail in that calculation that he provided, and we did not.
Okay, so back to my question just briefly. Your testimony doesn't go into those calculations and how you did them, right?
We go on to read. Do you mind if I?
Sure.
Okay. Contrary to Mr. Lee's assertion that the weighted average capacity factor he provided was for the CTGs SPS was proposing in this case, Mr. Lee's original calculation included existing CTGs on the SPS system in addition to generic CTGs beyond the CNP, the capacity need period, in the lock tail, in which, as I have previously discussed, was not optimized after the resource selection to maintain an apples-to-apples comparison between portfolios.
Mr. Gable, we'll get into the lock tail here in just a second, but right now I'm asking about the numbers on line 5, 18.8% to 27.6%. Your testimony doesn't go into how you calculated those or provide any work paper, right?
We did not provide a work paper, but we did provide that Mr. Lee's weighted average capacity factor used values for the generic CTGs that he characterized as the proposed resources in this filing.
So you said just a minute ago, though, that the source of the information that you used to make that calculation was a document provided by Mr. Lee in discovery, correct?
That is correct.
Are you referring to a document that was provided in response to SPS 2-1 to OPL? And I understand if
I don't have that in front of me. I'm sorry.
Mr. Gable, I'm going to share my screen real quick, and Your Honor, this is not a confidential document, and pull up a document that's been labeled as OPL Exhibit number 2, Analysis of Exhibit SPS LES 1-9. Give me just a second to do that, and hopefully I don't mess it up. Oh. Your Honor, apparently I don't have permission to share my screen. I clicked the request permission button. Okay, Mr. Gable, do you see my screen share?
I do see it.
And you're looking right now at an Excel file labeled OPL Exhibit number 2, Analysis of Exhibit SPS LES 1-9, correct?
Yes. Yes.
Okay, is this the document that you were referring to just a minute ago when you said the document that Mr. Lee provided in response to discovery?
Yes.
And subject to check, does this appear to be a true and correct copy of that Excel sheet?
Yes.
Okay. So, Your Honor, I'd like to move OPL Exhibit 2 into evidence.
It's your interrogatory response that Mr. Lee responded to?
It is a it is a document that Mr. Lee provided that was the basis for his weighted average capacity, or the work paper for his weighted average capacity factor calculation that Mr. Gable just told us he used to perform the weighted average capacity factor analysis, that the results of which are in his rebuttal on page 27, line 5. So the 18.8 to 27.6 numbers, Mr. Gable presents those as a correction to Mr. Lee, and this is, according to him, the document that, or the Excel file that he used to perform that analysis.
Well, I'd kind of like to have Mr. Lee verify his response.
I mean, Your Honor, we can do that if you'll allow me to do that when Mr. Lee is here, whenever that is, Monday or hopefully Monday, but sometime next week. Then I'd be happy to do that. For efficiency, would you mind if I examine Mr. Gable about it before he leaves the stand?
Absolutely. Go right ahead.
Okay.
And what number did you tell me that was?
This is OPL exhibit number 2. Your
Okay.
Honor. And let me know when you're ready for me to proceed.
Go ahead.
So, Mr. Gable, just a minute ago, we were talking about your proposed revisions to Mr. Lee's weighted average capacity factor calculation. And you mentioned that you used OPL exhibit number 2, this Excel sheet, to do your competing calculation. Can you explain to us how you came to your conclusion that the weighted average capacity factor for the Gaines and Tolk CTs would be 18.8 to 27.6% based on this?
Yes. Can you scroll down real quick? Okay. So on row 39,
Okay.
can you just click on any one of the items in there?
Any one of the values. Let's see, just let's do this one here.
Okay, so you can see that the sum product H6 through H16 and H25 through 35.
Okay.
So when you see that it's including rows 16 through 20, 16, I'm sorry, 6 through 16 and 25 through 35, it's including all CTs that he's showing here, not just Gaines and just Tolk.
Okay, so 6 through 16, that's all of the gas thermal resources up here, correct?
That's correct. Instead of you just using the Gaines and Tolk.
And then it then uses the projected capacity factor over the total capacity of the units to determine an overall weighted capacity factor. Is that correct?
Yep. So for as a example, you could change in your formula H6 to 16. You could change that to, if you scroll up a little bit so I can see the numbers.
My apologies.
No, you're fine. You could change it from H6 to H8.
H6 to H8.
Yep.
Okay.
And then H25 to H26. And then do that same H26 on the sum under, yeah, there you go. So right there.
6. Wait, hang on. Just clarifying, Mr. Gable. Don't you mean for this sum product H6 to H8? Don't you mean H7 just to have the gains in total units?
You're right. I'm sorry about that. Yeah, it should have been H7.
Okay, so 7, and then
And-
hit enter, correct?
Yep,
Okay.
that's correct. And then you could just take that formula and you could copy and paste it through that entire row.
Gotcha. And so if I were to do that, and we don't need to reproduce it here and waste time on the record, but then I would get your numbers, this range of 18.8 to 27.6, correct?
That's correct. I would just make a note here that it would be impossible to have a number over 28.5 because that was the capacity factor that was provided us in the bid as the limit, which was incorporated in the model.
Gotcha. So Mr. Gable, I'm going to hit Control Z here. And can you look at this and just verify that we're back where we were on the Excel file?
That's where we were at. Yes.
Okay. So thank you for that explanation. And now I want to go and I did promise you we would talk about this locked tail of the model. You read the relevant portion of your rebuttal already, but you more or less you argue that Mr. Lee's calculation included, so first, the existing gas thermal resources on SPS's system, and then also this line 8 here, which is generic future resources that were used for modeling purposes, right?
Yes.
Okay, so why are these generic future resources in the model? What is their function?
Excuse me. When we build out the model before we receive bids, the model develops resources. It uses our existing resources first to solution out our capacity and our energy requirements for every year. At some point, the model also additionally will select generic resources, just like in the IRP, to be able to solution out the future resources that would be required based upon assumptions on generic pricing and things like that. So the generic the CTF generic WSCR, that represents a theoretical resource in the future that the model says would help produce the least cost portfolio out through time. Once that model is established and it develops generic resources, which looks very similar to like what the resource runs in the IRP, we take out what we call the capacity period generic resources, which helps us identify a hole that we need to be able to solution. So we only take out the generic resources during that small sliver window between, in this instance, 27 and 30. And then we allow the model to select to fix that hole with the bids that are available. However, everything past 2030 through 2045 is left locked. And the reason we do that is so that when we're developing different portfolios, an RPS 30 incremental run or things like that, that we have some way to judge.
I'm sorry. Different portfolios on. Slow down a little bit.
Sorry, no. The different portfolios have to be compared on an apples to apples basis. So because we have this tail locked, we can identify the incremental differences between the net present values between portfolios. If we allow the tail to re-optimize for every single run, it's possible that the net present value difference that we're seeing is not because of the bid selection, but because generic resources in the tail are optimizing based upon the resource selection of resources today. So in the IRP, it makes a lot of sense to be able to have the tail unlocked and to develop these different scenarios for futures for things like that. But when we have to make comparisons to resources between portfolios, we have to lock that information so that each differential that we're seeing on the net present value basis is strictly isolated to the bids that we have provided.
Gotcha. So this locked tail, the information about these generic future resources, that's something that the individuals creating the model, they set that, right?
Well, the model is making the determination on what resources are there. But if you have a tail that ultimately is expecting certain resources in the capacity need period, and those resources aren't there, you may see different kind of things like this, where you're seeing a really high capacity factor because for these generic resources. If you allow the tail to re-optimize, it might select a different portfolio mix and bring that capacity factor down. So really looking at the capacity factors past 2030 provides very little value because we know that that tail is not optimized and is not the perfect resource mix in the future as compared to what resources were selected in this RFP. So you're sacrificing these different future looks to get the apples to apples comparison between bids that you're selecting today.
So what this model or this portion of the modeling is saying is that, for example, in 2031, if SPS were to incorporate the gains and Tolk CTs, those would run at 20.85 and 28.46% capacity factor, respectively. And, but then there would also need to be generic CTs running at an 89.06% capacity factor in order to serve all of the expected demand, right?
No, I don't think that that's really what we're talking about here, because what we're trying to use the model for today is to identify the best resources that are available in the RFP. If we want to understand out into the future what the optimal solution is based upon these resources, we would unlock the tail, and you may see a different development of resources. It might select less generic CTs or a different combination of resources, and ultimately bring that capacity factor down. So this capacity factor that we are seeing here is an artifact of the locked tail, and it's only telling us that the tail is not optimized based upon the portfolio that's selected, so that we can keep the apples to apples comparison between portfolios and understand the difference between the deltas on the net present values of each portfolio.
And if you unlock the tail and re-optimize, could that potentially impact the capacity factors of the gains and Tolk projects?
It could do that. It could bring it most likely down, because especially for the gains units, if you're at the 28.4, 28.5 level, you're at the capacity factor that was provided the bid, which is the limit of that. Ultimately, I don't know where that would go with this information because we didn't re-optimize the tail here. So this scenario, we don't know where that's going to go, but we do know that it won't go higher than 28.5 because that is that was a bid that was in as excuse me. It was part of the bid package that we received that 28.5% was the permitted limit. So it wouldn't go higher than that.
Gotcha. So that's the permitted limit for I guess you're saying the gains facility, correct?
And also the Tolk for CTs.
Gotcha. So it's possible if you had different resources instead of gains or Tolk, that these future CTs, these generic CTs, that their capacity factor projected in the future would be lower, right?
They could be lower, or they could be a different resource mix altogether.
Gotcha. So to the extent, I guess the point I'm getting at, and I'll move on shortly, everyone, I promise. But I guess the point I'm getting at is that what this is solving for is SPS projects that it will have a certain need for thermal capacity in these years going forward. And this is just the optimal way to run all of its units, regardless of what their characteristics are, the optimal way to run them all to achieve that. Did I say that remotely correctly?
I don't want to seem antagonistic. I would just say that because it's locked, And because we're trying to understand the difference between the portfolio selection on net present value, that information 2031 describing it such ways that that would be the optimal dispatch is not accurate. If you wanted to understand or ask that question, you would have to re-optimize the tail and see a different selection. So if we reran the optimization of the tail, it might select different types of resources at 2031, and you may not see these CTs at all. So to say that this is what the model is saying you need to run your fleet like to have the optimal run is not really accurate. This represents a lock tail, and so it can keep our comparison between the bids or the differences between the portfolios isolated to the bid selections.
Gotcha.
Excuse me, Mr. McMillan, if I can just ask a question. Mr. Gable, can you just share for the benefit of all of us what a locktail is and the controlling force it has in your modeling?
Yes. Thank you. Hearing examiner Schaefer.
Hearing examiner Schaefer. Yes, no worries. Thank you.
Thank you. So just to go back a little bit, when we're developing a model in both the IRP or RFP, we run the model to allow it to select generic resources out in the future to solve needs for which SPS does not have resources. So we have an incremental load increase. We need new resources to serve that for both capacity and energy. The model is selecting those generic resources that are not real resources. They're just theoretical building blocks out in the future. Once that is established, we have to lock the model so that nothing is changing in the model. And then the generic resources that we have in the capacity need period in 27, 28, 29, 30, any resources that the model selected to say that, hey, you need something here, there's a need here, we remove those resources to provide a hole to fit for the model to fill with bids. That still locks the tail, though. The tail is the period from after 2030, in this instance, 2030 to 2045. So those resources are locked. So any changes to the resource mix, you're only going to be seeing as impacted from the bids that are being selected. So you can see bid 161 here. It comes in column E, which is the year 28, right? So that's the first year that you're seeing that. It has an impact throughout the entire planning horizon, because when you created that hole in 28, you made a hole for it to fit in, but it still has other generic resources, because we're not trying to solve the solutions in 2035 or 2040. We are trying to solve needs today, but it has an effect long term. But we want to make sure that any impacts in the future are not controlling the model selection. So if we have a need in 2035 and we had taken out those generic resources, the model could potentially select a resource today because it sees that future and it needs to create a resource for it. It needs to solution it out. So we're trying to make sure that the model is only solution resources for the need within the capacity period of 27 to 30. Does that help?
Yes, thank you, Mr. Gable. I'm just want to make sure all of us, sort of have a general common frame of reference. So thank you for that detail.
Thank you, sir.
Okay, well,
Go ahead, Mr. McMillan.
Thank you for that, Mr. Gable. I'm going to stop sharing my screen and got a few more issues to talk about. Hopefully, we can wrap up my portion of your cross today. Let's see. I've lost my place. Give me just a moment. Okay, so can you turn to page 18 of your rebuttal testimony?
Yes, sir. Okay, I'm on page 18.
Okay, I'm looking at lines 12 and 13. The sentence starts rather.
Yes. Do you want to read it, or?
I can read it for us. Yeah, you say rather the CCGT inclusion reflected generic technology pricing at the time, and that's at the time of the 2023 IRP, which was lower than market. Did I read that right?
Yes.
Okay, so I want to talk about a little bit about the capital cost differential that was assumed between CCGTs and CTs. You'll agree that the generic capital cost assumptions for both CTs and CCGTs that were used in the IRP were lower than market, right?
That is correct.
And we've got this elsewhere in the record, so I'm going to say these numbers and just tell me if they sound vaguely correct, and we can associate them to the IRP reports later. But the assumed capital cost for the IRP for CTs was $782 a kilowatt. Does that sound vaguely correct?
That does sound vaguely correct. Subject to check.
Yeah, and once again, subject to check, the IRP modeling assumed a combined cycle unit would cost $1,116 a kilowatt, correct? Or vaguely correct?
It's in the order of magnitude. I think I remember some slightly different numbers, but I look a lot of modeling numbers, so but yes, go ahead.
That's fair enough, Mr. Gable. I'm just trying to set the scene for other facts, and we can verify those in the IRP report. So in your rebuttal testimony, and if you need to refer to it, it'll be on page 29 of it. On pages 28 and 29 of your rebuttal, generally, you're arguing that the informational bids received for CCGT resources were much higher than the CT bids that were received, correct?
Correct.
So the informational CCGT bids, those were from the Excel bid team. You mentioned that earlier, right?
Correct.
And SPS's actual CT bid that ended up being selected for gains, the bid came in at $2,072 per kilowatt, correct?
That's correct.
Okay, and Mr. Gable, I'm not going to close the hearing just to ask this one thing, but on page 28 of your rebuttal, you included the cost per kilowatt that you had in the informational bid, the lower of the two informational bids, correct?
Yes.
So we'll be able to refer to the confidential portion of the record for that. But would you agree with me that was the lower of the two informational bids was substantially more expensive than the CT or pardon me, I'll start over. Would you agree with me that the lower of the two informational bids for a CCGT was substantially higher than the actual bids for the CT?
Yes. Let's just read it back to you so we're on the same page. The lower informational combined cycle bid was substantially higher than the combined cycles that were bid in the or not bid, but that were provided in the IRP, correct?
That were provided in the RFP. So the informational bid for the CCGT, the cost of that on a dollar per kilowatt basis, it was a lot higher than the gains bid that ultimately got selected, right?
Yes.
It was on the order of like 150, 180%, something like that.
I can't specify on that.
That's fair enough. We have the confidential exhibit, and I don't need to not trying to get you to say it.
Yeah, that's fine. I understand.
Let's see. Okay, so in your rebuttal, one of the things you do is you rerun Mr. Lee's break-even analysis using a few different assumptions than he did. Is that correct?
That's correct. In general, Mr. Lee used the assumptions in the IRP. for the combined cycle.
Okay.
And I use the informational bid.
Gotcha. So that was my next question, was the assumptions that you use generally came from that informational bid from Excel, right?
Yes.
Okay. Let's see. And would you agree that because you use the assumptions from the informational bid, that the reasonableness of your modified break-even analyses kind of depends on the reasonableness of those assumptions?
My analysis is dependent upon the informational bid. Yes.
On the assumptions that were in the informational bid, right?
Yes.
Okay. So one of your proposed corrections to Mr. Lee's break-even analysis was to adjust the O&M, or operations and maintenance cost assumption, for the hypothetical gains CCGT to match the O&M assumption for the gain CT bid, right?
Yes.
So you discussed this, just so you can refer to it. It's your rebuttal, page 27, line 16, and then on over to page 28 through line 4 rather. So just so you have that to refer to when I'm asking you these next questions. So in your analysis where you updated the operations and maintenance assumption in Mr. Lee's break-even analysis, your rebuttal testimony doesn't specify the impact that change in isolation would have on the outcome of the analysis, and like the outcome of the analysis in terms of the break-even capacity factor, right?
No, I represented his change to be a potential impact of $103 on the net, $103 million on the net present value. Yes.
Gotcha. But you know, later for your other comparisons, you go into your revised break-even capacity factors for those, right?
Yes.
Okay, so you did, though, in the exhibits to your rebuttal, you provided a work paper that shows all of the various analyses you ran, correct?
Yes, and I think it's the confidential exhibit JLG R3. We provide each one of those steps. Yes.
And Mr. Gable, so later in your rebuttal on pages 28 and 29, you provide publicly, so not redacted, the outcomes, like the bottom line break-even capacity factors from some of your other alternative assumption scenarios, right?
Yes.
So is it possible for us to go without showing it publicly to that confidential exhibit and I just am trying to get publicly the bottom line result for the scenario where you just update the O&M assumption? Would that be something that we can do without giving up confidential information?
I think so. I don't think that. Do you want me to look at it first before we?
I was intending for you to pull it up on your end,
Okay.
and I'm just going to ask you about a specific, just the bottom line break-even number, and you know, to the extent, Mr. Larson, if you have issues with this, please let me know. I'm not trying to get into confidential information, but just to get like an apples to apples with the other analyses.
No, understood. Maybe we can just have him take a look at it and see where the questioning goes and evaluate
Yeah.
it as we go.
Okay. And Mr. Gable, let me know when you get there, and I've got just a couple of questions about it.
The paper documents I have only just specify that it's available. Let me just give me 1 second. I apologize. See if I can navigate this. Mr. McMillan, I'm sorry, but I'm not so sure I know exactly where.
So I can maybe direct you to it. So it'd be JLG R3 conf was what it was labeled in my files. And then there's a tab all the way to the left, exhibit JLG-R3A.
I think I found it. I'm opening it right now.
Okay.
Okay.
And for everyone's benefit, I'm within a couple of minutes of being done. So my apologies for the dragging here at the end.
I have it.
No apologies necessary, Mr. McMillan.
You found the file and the tab that I was referring to, Mr. Gable? Like it was all the way to the left in my version, JLG R3A.
Yes, I have it.
Okay,
I do have it.
I'm not asking you to talk about any of the confidential portions of this, but I'm looking at cell B as in boy 29 at
Yes.
that break-even number. Is what I'm going to be asking you about. So first, can you confirm just by looking at the tab that you're looking at that this is the analysis that you did where you just updated the O&M assumption? Can you
Yes.
confirm that? Okay, and can you tell us what the break-even capacity factor was from that analysis in cell B29?
Okay, so assuming just the fixed O&M is matching between them without changing any other assumptions, 24.4% is the break-even analysis result.
Okay, thank you, Mr. Gable. And now I have one, while you've got that document open. So on page 29 of your rebuttal testimony, it's you say it a couple times on line 5 and then line 6. You're talking about a scenario where you update the capital cost to your assumption and you update the fixed O&M. And you say that results in a break even of approximately 29%. Can you go in your exhibit JLG R3 and go to the tab labeled JLG R3C? And we're gonna have the same. I just am looking to get the correct break even capacity factor.
Yes, so I'm looking at exhibit JLG R3C, and this is the corrected heat rate and fixed O&M, and I see that number now.
And in that scenario, using your capital cost and O&M assumptions for the break-even analysis, what is the result that's shown in cell B29?
28.7.
And Mr. Gable, I believe that's all I have for you for now. Thank you so much, and Your Honor, pass the witness.
Thank you, Mr. McMillan. I believe due to the lateness of the hour, we will recess our hearing and we'll come back tomorrow morning at 9 and resume the cross-examination of Mr. Gable. So thank you all for your participation. Mr. Lee, I think we can go off the record now. Thank you, sir. And
Thank you, Judge.
Again, just briefly discuss where we're headed for tomorrow. So basically, when we finish, I believe in the morning, hopefully, with the cross-examination of Mr. Gable, Again, I believe Mr. Lytle has been moved in the order. So then we'll continue with Mr. Gertz, who it looks like we have right around, at least now, looks like about 3 hours. And then we have various other witnesses in SPS's order. And again, I don't know if SPS has anticipated making any changes other than the one that they've announced. But again, I just encourage you to let me know, let the parties know, let hearing examiner Schaefer know. I'm kind of concerned about the unavailability of the 4 witnesses, at least at the beginning of next week. And then the 3 witnesses that aren't available at all next week for SPS. So we've got to make sure that we get the SPS witnesses. I mean, obviously the ones that can't be here at all next week. Yeah, those witnesses have to get in this week. And because I don't want us coming back for the 3rd week. You know, I mean, it's really going to help the continuity of the hearing if the witnesses that are not available at the beginning of next week, that they don't have to come back at the end. So I just put that out there. And if anybody doesn't have anything else procedurally that we need to discuss, thank you all. Hearing examiner Schaefer, anything, sir, from you with regard to procedure?
Yes, thank you. I would just really echo what you have just shared with all of us. The continuity and integrity of the proceedings is something hearing examiner Hurst and I take very seriously. We're doing everything we can to accommodate SPS on their requested schedule, as are all the other parties. So the availability of the applicant's witnesses is greatly appreciated. Not just from our perspective, but we speak in this case for all parties. So I would just ask that the counsel for SPS take that into serious consideration. And that's all I have to say. Other than thank you, everybody, again, for your professionalism and patience, and we look forward to seeing you again tomorrow.
Thank you. And I would just note for people who haven't been checking their email, we did issue the order on the motion to eliminate and the motion to strike this afternoon. Yes, we can multitask. Excellent. Thank you all very much. And we are recessed until show up at 8:50 if you have procedural things. Otherwise, we're recessed.